Hello and welcome back to another episode of True Crime Metrix. Yeah, having some trouble with this mic. It's like, oh, we're on mute. Your mic is unplugged. It's not unplugged at all. What are you talking about? Oh, what are we looking at tonight? We're looking at Sarah Boone, but first, Charlie Adelson, huh? New trial, huh? Well, this is going really well, isn't it? What have we got so far out of this, guys? We've got Luis Rivera, who made the deal of a fucking lifetime. 7 years on top of the 12 he was doing already. Let's have a look at him. Where is he? Here's Lewis. Hang on. Look at him there. Yeah. Is this a murder case or a Latin King case? This ain't no Latin King case. Yeah, 7 years. Wow. I mean, okay. I mean, that'd be fine. I've always been all right with that. He was a major part in producing evidence, in giving leads. I mean, major part. Bags of verifiable information he gave to the FBI. And okay, it's a hell of a deal, but it is what it is. You got to do a deal sometimes. Then who have we got? We've got Sigfredo Garcia, who probably, in all likelihood, knucklehead that he is, would have ended up doing a life sentence anyway. All we've got with him is one more shitbag off the street. He's not really involved. I know he pulled the trigger and blah, 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 but do you think that satisfies the mandate for justice? Then, another lifer, Catherine Magbanua. Look at her hair. She just looks like a sick, lonely dog that's lost, and doesn't know where to go. Bearing in mind, I've always said, if anyone is, I'm not making a case for her, don't get me wrong, but I'd say of anybody, she's the least culpable or least knowledgeable about anything, and there would probably be a way, to cut her a deal and let her out that wouldn't completely be a mockery of justice. Okay. You could let her out and say, listen, bitch, you're on a fucking choke chain. You so much as go a quarter mile over the speed limit and you're getting the death penalty. You're looking after your kids. You keep your nose clean and your mouth shut. You're getting an online job and we're shutting you away in a room. You're on a 3-mile tether range, constant ankle bracelet. Anything happens to that bracelet, death penalty. You're allowed to Walmart once a week. That's it. You support your kids. You try and help them not become a selfish, corrupt bitch. And that's it. You're an embarrassment to anyone who's ever known you. You're an embarrassment to your kids. But we're not going to pay to take care of you in prison. And we're not going to have your brother pay to look after your kids forever either. Online job, 3-mile tether. One step over the line, death penalty. And not a ceremonious one either. We're going to let Ruth Markel do it herself. We're just going to come into your house, drag you outside, and put a bullet in your head. That's it. That's the deal. I'd sign up for that. If she could give a load of information, we want to have every information. Or the other choice is, Katie, stay in the concrete shitbox, sit next to a toilet with no seat and a gym mat fucking pillow. What's it going to be? And then Charlie first. Let's do Charlie first. Charlie with the trademark tree trunk elephant leg neck. I mean, you could fit his entire face in his throat. What is that? I don't know. It's horrible. Call me crazy. I like a good neck on a person. Not this. Look at these rolls of fat. Horrible neck. So he's got a new trial, huh? Because Dan Rashbaum was an unethical piece of shit snake of a lawyer. And I've heard it said with all of those lawyers, those actual lawyers, that I'm not, that They don't think that it was a ploy or a scheme or a plan, that all of this conflict stuff came up and just completely derailed the trial of Donna, and now has probably given Charlie Adelson a clear route with no argument against to have a new trial. Are you kidding? I mean, why don't we just let them all out? You know, why don't we just dig up Professor Markel's body, run it over with a dump truck, cut it into pieces, and scatter the remains across the diamond of the Toronto Blue Jays fucking Skydome Stadium? You know? I mean, talk about insult to injury, salt in the wounds. Hey, Ruth and Phil, how'd you like to make the trip down to Tallahassee another 4 fucking times and look at the autopsy pictures of your dead son? What the fuck is going on, Jack Campbell? Jack Campbell, resign. Resign today and slit your wrists. You're a piece of shit. You know nothing. What did he say in that interview? He said, oh, there was a lot more preparation with this. Example, usually we don't have headphones for every jury member, but we did on this occasion. That's your headline? That is your headline. Instead of getting 6 to 8 pairs of headphones, you had to get 12. Just think about that. In his mind, that's worth mentioning. You know, I don't really understand what he does. I'm not, you know, fully informed about stuff like that. But I know how to spot, I know how to spot a person in business or in law or in medicine or in education or whatever it is. I know how to spot a person that can jive, right? And how to spot a person who's a worthless piece of shit, nothing, stain on the rug. And you, Jack Campbell, are a stain on the rug. You know, just go. What are you doing there? The fact that you're in office is a complete mockery to the system that office represents. You are so transparently incompetent and fucked that you fucked this whole case. You know, but what are we going to... I mean, he should just give Georgia Kappelman his job. You know, I'm not ready to say anything bad against Georgia. You know, she's a great trial attorney. That's her focus. Jack Campbell's supposed to be, you know, juggling these other balls in the background, as far as I understand, right? He dropped them all. Every single one, all at once. Prick. You know. And then Donna sits there moaning in jail, looking at white-collar attorneys, shopping for a lawyer with her ginormous ears and her falling off her skeleton face. Meanwhile, this person has just had a nice, healthy extension added to her free time on Earth. Right? Look at her, laughing all the way to the bank of non-justice. She is free. And guess what? The prosecution the prosecutor's office that is responsible for making her not free anymore has just been fucking tied up, fully loaded for the next 2 to 3 years. Okay? What's the problem? What is the excuse? Is the office saying, well, we're not sure we have enough evidence to convict, or we're not sure we have enough evidence to arrest? Well, why not? We've all been looking at the evidence for fucking years, and there is. So why isn't she? What is the deal with that? Ben, this guy. I mean, look at him. What kind of face is that? What the hell was he involved in before all this? This family, if you're going to totally normalize something like pulling off a hit and hiring gun thugs to do this big drive up to Miami, if that's totally normal to you, what the fuck else is he involved in? You don't just break bad at 60, 70 years old, right? And he looks like a villain, doesn't he? Not many pictures of him online. And what about the cost? The cost. I mean, I don't give too much shit about the costs, but I do think it's worth mentioning that this investigation and prosecution, multiple fucking trials, and the huge level of investigation that went down, the every bus camera in Tallahassee, every SunPass Prius in the state of Florida, every fucking cell tower for a 400-mile drive or whatever it was, you know, the bump, the wiretaps, the surveillance, the fucking FBI agents going to the sushi restaurant and ordering California rolls. That all goes on the bill. How much is a California roll in a sushi restaurant which an Adelson would frequent? Probably $25, right? All goes on the bill. It must be, you know, I am totally guessing here, and I might be way off, but I would guess that the investigation alone, aside from the prosecution, was in excess of $20 million, maybe 30. You know, that's got to be high up. That's got to be like way higher than usual. And we know it was a seriously extensive investigation, right? I mean, huge. But anyway, well, I think I've got that out of my system now. Like I said, not much more to be said about these fuckers. You know, apparently Judge Everett, apparently the Charlie Adelson attorneys, you know, you all saw Carl Steinbeck's video, very, very good. Apparently Charlie Adelson's attorneys have petitioned the appellate court to put the ruling back to the trial court. So Judge Everett's going to get a nice order on his desk saying, well, Daniel Rashbaum was unethical and didn't give a good representation to his client, or however you say that. And yeah, new trial because, you know, unethical, unconstitutional. It invalidates the whole process, right? It invalidates his verdict. So I believe he's already been transferred to Leon County. He's not going to be in prison anymore. He's going to be awaiting trial again, shopping for lawyers. You know, and did I already say this? You know, someone like Dan Rashbaum, who we know is a slippery, lying, unethical piece of shit lawyer, right? And I'm all for lawyers doing lawyer tricks. That's what the system allows for, you know? Christopher DeCoste does his tricks, and I like them, right? And he's effective. Daniel Rashbaum wasn't effective. So I don't like him. I think he's terrible. And I think, you know, his bar card should be burnt. Just burn it down. Never practice again. I mean, fuck me. But yeah, back to the subject of mentor lawyer and Carl Steinbeck saying, well, I don't think it was a scheme or a ploy or a plan, and this just happened. It was no one noticed. Yeah, okay, well, maybe. But, you know, if you've got a lawyer that represents himself like Daniel Rashbaum does as a sneaky, fucking lying, slippery snake piece of shit lawyer scumbag, and, oh, look, it just so happens that with that lawyer, there was this amazing fallout of terrible question of ethics and misrepresentation with multiple. I can just see him sitting on the couch in the Icon fucking building with Donna and Harvey planning this and saying, listen, what we'll do is you'll retain me all the way back from 2016. Even if I've got nothing to do, we'll start a paper trail. And that'll show that I've been involved in representing you. And it'll show that my loyalty is mainly to you. So if Charlie ever does get arrested, you'll vouch for me to represent him, and I'll fly in and represent him. And if he gets convicted, eventually, we won't do it straight away now, but eventually we'll raise this question of the ethical the lack of ethics in my representation of him, which will probably grant him a new trial. And if we're lucky, the prosecution and the judge are going to be too busy to notice. And they were lucky. I mean, I can see him coming up with that. And the fact that it's happened when, you know, if it happened with an ethical lawyer who didn't know and blah, 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 you would have to go, well, that was just bad luck, wasn't it? But it happened with this guy. And it's like, wow, that's another big coincidence, right? It just so happens that this crazy thing happened with Daniel Rashbaum. So I'm not convinced that it's not a ploy. I don't know why the big wigs like Mentor Lawyer and Carl Steinbeck are so quick to speak against that idea. I mean, I could be completely wrong. Yeah, they know a shitload more than I do, but I'm not, it's not been explained to me why that is so far-fetched. I mean, it fits the character as far as I'm concerned. But anyway, today, little sidetrack introduction there. Okay, so we should get back to today's video actual subject. I just needed to comment, especially after my tantrum the other night with the Wendy Adelson. Sorry about that, guys. It was just so damn hard to get through that fucking video of that stupid Wendy Adelson. You know, it's not good for me. I shouldn't look at her for a little bit because it's just too upsetting, right? It's just too much to deal with. Anyway, not that Sarah Boone's much better, but that is the subject of today's video, my friends. So we will be switching to that right now. Welcome, everybody in the chat. Neverly, darling, so good to see you. And Linda, of course. Right in. Colleen. Welcome, everybody. Adelweiss. Lolly, Keith. Good to see you, Keith. Piebird. Love the name, Piebird. Those two words should go together more often. Piebird. The bird of pies. Yeah, Tracy, good to see you too. Okay, so are we ready? I think we're ready. Now, there's quite a few extended silences. The big clock, the Florida seal, but we'll do some skipping. I think the beginning of this video has about 10 minutes of Boone sitting at a desk in a suit, in a horrible suit. It kind of looks even more bizarre that she's got the chain on with the suit. You know, usually she's in the prison scrubs, but there is no sound on the video yet, guys. There's about 10 minutes of Boone sitting at the desk, like I said. I mean, maybe we'll just watch a couple. I just find it interesting to watch her pretend to be like, you know, see her there with the binder, like moving it around, like setting up, you know. Yes, this page looks good. Yes, okay. This is a good page. And where is my pen? Where can I, do you have a peppermint? I would like 5 peppermints. you think Mr. Owens is regretting his choice yet? I mean, it's not really, going all the way he thought it might. I love Judge Cranick as well. I've had mixed feelings about Captain Cranick, Pilot Cranick. But it's funny because he's got these two speeds, right? He's either really patient and thorough in explaining things slowly and clearly, which I like because I learned from it as well. Or he gets really impatient and there's not really a middle ground. Right? So one minute he's like, the order was sent from the prosecution to uh, omit certain elements from the videotaped interrogation. He's really slow and patient, and then all of a sudden he's like, "We're not doing this now. We're not. No. Like, you need to put it in writing. We're not." It gets flustered very easily, and I can see why. Right? It's a very flusterable case. Just having Boone within 20 yards of myself would fluster me like a hen in the hen house. Ruffle my feathers. Okay, that's enough sitting and staring. Oh, she's gonna get all her papers together now. Well, I've just gone back. What the fuck is this? What is she? What was that? What is she doing now? Any lip readers out there? I'd love to know what the hell she was saying. I got the last bit. Thank you. See, Boone thinks if she says please and thank you, that means that she looks like a good citizen. And all the other stuff about her character doesn't mean anything. If she just says please and thank you and sits up straight, the jury is going to love her. That's her theory, right? And she actually believes that she comes across well, you know. Okay, let's skip ahead here. We don't have all night. I don't know who the fuck this guy is, but I think we're about to see. I've watched a little bit of this. I haven't watched it all the way through, so I know that we're going to have some things to say about Mr. Blue Suit over here. I mean, I thought he had two young female paralegals that were ready to go, right? They were going to do Sarah Boone's makeup in the fucking on the defense table in a rush before trial. What happened to those girls? Maybe Mr. Owens started to make them feel uncomfortable. Yeah, I get he's the second chair, but I, I haven't seen his presence be announced. It just seems a bit like suddenly he's here. You know, and from when he starts to speak, it seems like they just found a guy on the street and put a suit on him and said, come on, you can do this." It's easy. It's easy. Don't worry. You don't need training. We're just going to get it done. Okay. But we'll give you $20. $20. You'll be able to get the bus home and everything. How's this audio going, guys? Is my audio okay? I know that we don't have audio on the video yet, but how's this audio? Is it good? Hello? She wants some sugar pies and moonbeams.
James Owens on behalf of Sarah Boone. Tony Henderson on behalf of Sarah Boone.
Ah, good. Thanks, Derek and Neverly. But now we've got to match it with the video audio, which is not exactly everyone's mic isn't on. So I think we'll base it on the judge speaking, and we'll match the levels with the judge. So let's wait for him to speak.
I do.
Ma'am, good morning. Can you state your full name and date of birth for the record for me?
Don't ask her date of birth, and someone admonish her for saying it like she does. 10-10-7-7. Listen, lady, it's October 10th, 1977.
Sarah Boone, 10-10-7-7.
All right, Ms. Boone.
How, I wonder if she has that tattooed somewhere.
Boone is seated at counsel's table wearing a gray suit and a white blouse. She is out of custody and unshackled. Mr. Beck, you arrived late, sir. Can I get your appearance for the record, please? All right, thank you. All right, we're here on a litany of different matters, multiple motions in limine. The state's motion in limine to exclude battered.
A litany of limine. Yeah, we're on here on a litany of limine motion.
Spouse syndrome evidence or exclude mention of battered spouse syndrome evidence until the defendant testifies to a justifiable use of deadly force, filed October 6. Defendant's response to state's motion in limine to exclude battered spouse syndrome evidence or mention of battered spouse syndrome evidence until defendant testified filed October 15th, and then the defendant's amended response to same also filed October 15th. The defendant's motion in limine filed October 6th. The state's response to same filed
Vivian, welcome.
October 6th. State's motion, objection and motion in limine to exclude decedent's medical records filed October 14th. And then the party's objections with regard to specific exhibits that may be sought to be entered at trial. The court has reviewed everything and reviewed all of your case law, and we're ready to proceed. I believe we should probably proceed first on the battered spouse motions first. So state, you may begin. And I also have reviewed as well the excerpts of the deposition of both Dr. Warner and Dr. Harper as identified in the state's motion.
I think this is a little break. Not much.
That she made on body worn. Your Honor, for the record, I'm having Madam Clerk mark A, B, and C for identification purposes for this hearing. A is a copy of the defendant's statements that she made on body worn camera to Deputy Sheriff Kayla Rodriguez on February 24th of 2020, as well as the interview that she provided to Detectives Copsel and Lowen on February 24th, 2020, and February 25th of 2020. It is an identical exhibit as to what was provided to the court for review in chambers as a courtesy before the motion to suppress statements, as well as what is entered into evidence for that motion to suppress statements hearing that was held. State would move A for identification purposes, in as 1 for the purposes of this hearing.
Responses to what was pre-marked as A.
No objection.
All right, what was pre-marked as states A.
I was so psyched for him to go into a raveling objection, stood up and everything, supported his upper body weight with both palms on the desk. Dramatic pause, and then no objection.
Will be received without objection as states 1.
B for identification for purposes of this hearing is the deposition of Dr. Harper. We would move that into evidence as states 2 for the purposes of this hearing.
Any objection?
No objection.
All right, what was pre-marked as B will be received without objection as states 2.
I think that's going to be his party line, right? It's no objection, Mr. No Objection.
2.
C for identification for purposes of this hearing is the deposition of Dr. Werner. State would move that into evidence as states 3 for the purposes of this hearing.
Any objection? All right, what was pre-marked as states C will be received without objection.
You should just get a little sign to hold up. No objection. Instead of having to speak the words, just hold up. No objection.
As states 3.
Your Honor is familiar with all those exhibits and has been able to review them prior to the hearing, so I will just proceed to the legal argument.
You may proceed.
Your Honor, this is a motion to eliminate. We are asking for a pretrial ruling based on the proffered statements that the defendant has made, which should, in good faith and reliance, the state should be able to assume that that will be her testimony at trial, given that her latest version of events was just given to our expert last week.
This guy's basing a prediction of Sarah Boone's testimony on good faith. I think that's a mistake, man. I think we can expect the opposite of that. Yeah.
So we are asking for a pretrial ruling on if that is the evidence that comes in at trial, will she get a self-defense instruction? Will she be able to then open the door to all the things that come with self-defense, such as reputation evidence of the victim for being violent, which she may or may not be aware of, that's not required under the law, or prior instances of violence between she and the victim, or the victim and anybody that she is aware of, because that goes to the reasonableness of her perception of an imminent threat of death or great bodily harm. We are not asking to not be allowed to talk about these things during voir dire. The defense cited numerous cases and spent some of their time in their response about the ability to voir dire. That was not the purpose of our motion. I don't think we mentioned voir dire because we understand that the defendant can, like any other witness, change her story again. So we understand that we both, on both sides, we intend on spending a great deal of time on it as well for the state of Florida. We need to explore these issues during jury selection. But what we are asking from the court now preliminarily is, if that is what the defendant is going to say in trial, and I'm not asking the court to make any credibility determinations about one version or another. We're asking you to treat this just like a C4 motion or a motion for summary judgment in a civil case. If this is what she says, does this amount to what they are asking for legally? And it's the state's position under the case law that no, because under her statements that she gave to the experts, there was no overt act taken by the decedent on that day. There was no overt action. And that's what's required under the law to trigger her.
Yeah, right, Colleen. Do we think that Sarah Boone is going to be a doodler in court? You know, like an Ezra McCandless or a Jodi Arias? No, I was doodling to maintain my sanity. What do they always say? This has been a traumatic experience, and I need to doodle. This is my doodle of a dog.
response of acting in self-defense. There was nothing creating an imminent fear of death or great bodily harm to her until she committed 2 forcible felonies and a non-forcible felony. What her testimony is we were having a good day. Now, what's different, and again, we're not asking you to make a credibility determination about what's different, but what is different than what you had heard at the motion to suppress is
The Pop Tarts thing. I don't know if I should comment on it so early as it hasn't been brought up in the courtroom yet, but I just knew that Sarah was a major Pop Tart fanatic, right? That was her daily bread, so to speak. It was just like, boxes of Pop Tarts. She'd go to the Publix. It'd be like a box of wine, box of Pop Tarts. We're done for the day. That's our shopping, our daily shop. Pop Tarts and cheap wine.
we were having a good day, but I'm on edge every day because of past instances of violence, including an instance the night before. But we're having a good day. We're out on the porch. There's a dartboard out there. There's puzzles that we're doing. We're doing arts and crafts. We're doing everything to keep.
Can you play darts when you're 4 times the legal limit of intoxication? That just doesn't seem sensible or safe, and especially on a balcony. Sorry, neighbor. Got you again, huh?
Keep him preoccupied so he doesn't get sad or upset. Interjecting with some phone calls to his family, which she knows would potentially upset him, but that's her testimony. And then eventually it comes to a point in time where they're sitting on the couch and he reaches over to her and says, "Tag, you're it." And she apparently runs up to the shower to hide, and he apparently gets into the suitcase to hide, and it's not clear who's it. Eventually she comes.
Yeah, they both hide from each other and sit in wait for a couple of hours until Sarah gets too cold. What a pair of knuckleheads. That's their evening entertainment. We think we're both hiding, so no one's seeking. It's hide and hide.
Down out of the
Hide and go hide.
shower after she says she was getting cold up there, and sees him in the suitcase and zips him up. And at the time that she zips the suitcase, what she describes is nearly entirely shut, but 2 fingertips could get out. Mind you, 103-pound man, 2 fingertips.
103 pounds. I mean, what is that? I didn't even know it was possible for a man, a fully grown 42-year-old man, to weigh 104 pounds. That's like an 11-year-old boy, isn't it? I mean, that's ridiculous. What could he do? I mean, she could probably throw him across the room,
They're laughing. It's all fun and games still. There's still no overt act taken by the decedent during this entire calendar day to put anybody in reasonable fear, objectively reasonable in fear of imminent harm, of great bodily harm or death. And it's only when he begins to say, after she has zipped him up into the suitcase, and again, she is saying that she did not have malintent at that time. When he starts to say, "I cannot breathe," now she describes to the doctors that she does have bad intent, and she wants him to feel what she has felt in the past. So
this whole motion is about precluding, as far as I understand it, it's about precluding the concept of introducing character evidence that would support that she was in fear. of George grievously bodily harm or death, you know. But she's basing that on that the prosecutor's basically saying that if she can't tell us what it was that made her feel that she needed to act in self-defense, then she can't demonstrate that by further backing up past instances of you know, why she was so in fear. But she's basing that on when he said he couldn't breathe in the suitcase that I recorded. That's when I knew that if he got out, that he would beat me to death. Yeah, the 103-pound man was going to beat me to death. But the thing is that portion, that's the worst thing she could say, because that's the portion that's recorded on video where she's laughing and cackling like a drunk witch and saying, "Fuck you. This is what you get when you cheat on me. This is how it feels when you choke me. That's my name. Don't wear it out. You should probably shut the fuck up." You know, that's the worst possible example she could give to say that that's the moment that I was in fear for my life.
It's angry is her description. She shakes the suitcase, she beats it, it falls over, it flips over, he sticks his fingertips out, she hits him with a bat. So she's now the initial aggressor, and we'll discuss jury instructions as we get closer, but she's the initial aggressor, and she has now committed forcible felonies, aggravated assault, and aggravated battery, stating that I only intended to keep him in there for a couple of minutes. I believed he could get out. She never perceived, according to her, that he would die or face great bodily harm.
That's probably true. I mean, I really don't think she left him in there to die. I think she went upstairs and left him in there because she thought it was funny and a punishment and awkward and uncomfortable and all the rest of it, you know, and probably didn't even intend to fall asleep. But as many of us know, when you're that drunk and you go anywhere near a bed or a place where you can lie down, it's very easy just to suddenly be in a deep, deep sleep, right? You know, bad idea. She fell asleep by accident and didn't even remember in the morning where he was. That seems to be true in my mind.
And she just goes upstairs knowing now he's mad because she won't let him out. Now, because of the actions she took as the initial aggressor, she is facing death or great bodily harm from the decedent if he gets out. And she completely expects him to get out because her testimony is that he could get 2 fingertips out of the zipper.
Lolly77, you say 5'2", 103 pounds. Was he only 5'2" tall as well as being 103 pounds? I mean, that is an 11-year-old boy. I mean, with a goatee and a job at Ace Hardware. Remember when he got arrested and he still had the Ace Hardware shirt on? Maybe we should watch that video in a second. It's like he never takes it off. He was so proud of his job. And his manager was awful. He said, "George, you're not coming in, and it's the 3rd time this week. We're going to have to let you go." They didn't support him.
So, Your Honor, under the law, the state understands. We are deeply, deeply thoughtful about this request because of the risk of error. But this is just one of those cases, like the cases the state cited. There is no self-defense if that is what her testimony is. And therefore, the jury should not hear about any prior instances of violence, any reputation evidence, any battered spouse syndrome, unless and until there is testimony that is self-defense that's recognized under the state of Florida's laws. So what we're asking,
Yeah, Linda, he was a big time ace worker. He'd stack cans of paint on the shelves and check they had enough hammers in stock. Real, it was his passion. It was his big passion.
for is a ruling that if, and this is a motion in limine, and a motion in limine is, hey, this is what's proffered to the court prior to trial. If this is what comes in at trial, this is the court's preliminary ruling, unless something changes. What we're asking for is a preliminary ruling that if that is what her testimony is, then we should not be allowing introduction of past instances of violence, reputation for violence,
Go ahead, sir.
or battered spouse syndrome evidence. And furthermore, what the case law supports is our request that clearly this evidence can only come from her. There was nobody else in the apartment or townhouse that night. So she should have to testify before any of those things come in. And her testimony should meet the requirements of an overt act before any of this testimony comes in. It should not be allowed to come in prior to her testimony. And under the case law that the state cited, it's not unfair. It's not forcing her to testify. She chose.
Hey, thanks so much, Evan, for the coffees. That is much appreciated, my friend.
To raise battered spouse syndrome. The state completely understands we have the burden of disproving self-defense beyond a reasonable doubt. But what the case law says is we shouldn't have to combat this. We can't put the toothpaste back in the tube until she actually puts forth the self-defense that justifies all this. So that is our request. We're not making any requests about voir dire because we understand she can come in and testify differently yet again at trial. And that's a discussion we'll have to have as well about how that will occur. The state's position is that if she changes her testimony yet again, she should have to give a narrative testimony. No attorney should be allowed to participate in putting forth new testimony about the events of February 20th.
Look at Mr. Chicken Cacciatore.
Participate
Everything about him. Look at this posture.
in putting forth new.
He looks like he's in a friggin' shisha bar, shisha lounge. What is that posture? Everything about him I find like borderline offensive. Like he just doesn't quite get how, like, his mother never taught him how to, use a knife and fork properly in a restaurant. Oh, it's just like, what is that?
New testimony about the events of February 23rd. Thank you.
All right, thank you very much. Response.
All right, you ready for a big response from the new man in town, Mr. No Objection? I swear to God, man, they found this guy in the bus station looking for spare change and said, come on, we need you. Here's $20. We're going to throw a suit on you. You can do this.
Good morning, Judge.
Morning, sir.
I'm a little confused, but I want to make sure, so probably can save some time here. My understanding is what the state's saying at this time, that there's no objection to raising this in voir dire to see how the jury would react or their feelings about it. So that's not it. So what that leaves.
Why would there be an objection to it happening in voir dire? I'm pretty sure you can say anything in voir dire because that's part of the selection process. I mean,
leaves me is, I guess the state's trying to say there should be no mention of battered spouse or anything like that in opening statement.
That wasn't my takeaway either.
Again, opening statement is not evidence, right? I mean, you can draw on pretty much anything in opening statement because it's not part of the case, really. It's separate from what goes back to the jury room, the deliberation room. You know, the judge often says what the lawyers say in opening statements and closing arguments is not evidence. You are not to rely on it as such. I mean, it comes with its disclaimer.
My takeaway from the motion and the state's argument today is from a evidence perspective, concepts or testimony or even opinion evidence about battered spouse syndrome cannot be raised, including any of the reputation or specific instances of conduct that are contemplated by self-defense until there's a factual basis for it. My understanding
Until there's a factual basis for it that hasn't obviously been introduced or confirmed yet. So the motion in limine, the state is seeking to have it precluded as an order, a written order on paper. This is not allowed unless you provide a what did he just say? You know, a factual basis for an event that caused her to fear and act in self-defense. What was that event? What is that basis?
of the defense's Dr. Harper's deposition is that the basis of her opinion, and please correct me if I am wrong, but my understanding is that the basis of Dr. Harper's deposition is based on her 4 or 5 interviews or sessions with Miss Boone as to what transpired on the day and night in question. Is that accurate?
I need to confer.
Sure.
I need to confer. It's my first day. Is anyone else getting strong Chief Mac vibes from this new attorney? You know? Is he going to turn around to the judge in a moment and say, "Judge, I just ordered the Smokemaster 3000. That's the barbecue of the future. Okay, Judge, I need this job. Okay? I got a whole brisket ready to go. I've been marinating day and night, and I need this job."
Judge, if I could have you repeat that question.
Sure. So,
Judge, if I could have you state your order now. Do you want your steak bloody as hell or burnt to a crisp?
my understanding, well, let me ask you, I'll have a more of an open-ended question. What is the basis factually of Dr. Harper's opinion? So if we were at trial right now for the purposes of this exercise, and you were going to call Dr. Harper to testify, what is the factual basis component under 90.702 in order to get her to testify? We're not dealing with her CV, her credentials. I'm not sure the state's going to have any position with regard to those, but let's just assume the state has no objection with regard to her credentials and that she is in fact an expert based on her knowledge, training, and experience in her field. What is step 1 under 90.702 to allow her to testify? What is the sufficient factual basis of her opinion?
Judge, I think her opinion would be based on several different things. Mainly, one of the things that her opinion would be based on is her interaction over the course of time with our client, Ms. Boone. That's one. But Dr. Harper has also reviewed other evidence in this case that helps her form the basis of her opinion and also her knowledge of battered spouse syndrome. That has to be taken into account because, quite frankly, Judge, people who suffer from certain things, they don't know. That's why you have to, like if you have to get an expert opinion as to someone's mental health situation. I mean, a person doesn't really know that they're suffering from a mental health problem. They have no idea in a lot of circumstances. What they do is they get evaluated by a doctor. The doctor has experience of what signs to look for in these things, and getting those signs with what they told and outside sources too. They are able to make a determination based on their training and experience. So,
But based on the Akendo case, which is cited by the state as to what battered spouse is it's an ambit of self-defense. So under the statute, are you traveling under 776.012 as your basis for self-defense?
yes, but this is the problem that I'm having here. Self-defense is a defense, it's an affirmative defense that's available to anybody. It's based on the evidence at trial.
But what's the overt act? Because in reviewing Dr. Harper's deposition, there were specific questions by the state inquired of her about the language, specifically in those statutes, about the imminence of fear. And she was unable to answer those questions. So my question really is, what's the overt act by the victim which would have given rise to self-defense? Because the case law, taking aside the state's case law under the stand your ground concepts, which I find distinguishable, because under 776.032, there's a specific statutory scheme for pretrial stand your ground motions. So I find those cases distinguishable for that very reason. But there's specific case law, bless you, there's specific case law that talks about in the self-defense realm that the state has cited to in their motion that an overt act is needed. What is the overt act?
Judge, the overt act has to come from testimony, and I agree in this case, but that has to be the testimony of Sarah Boone for that overt act. And that testimony can only take place at trial. In making a determination of whether to give the self-defense instruction, it has to be based on the evidence presented at trial.
I agree with you.
He's acting like it's a special event, like a surprise that's coming, and the judge is going to ruin it if that surprise is revealed too soon. Like, it's his client. The judge is asking the lawyer, what is the overt act? And so presumably he knows this after speaking with Sarah. They're not in trial. The jury isn't in the room. He's allowed to say what is the overt act. And the lawyer is saying, Judge, that has to come in the form of witness testimony, which can only come from the defendant, Sarah Boone, Miss Boone. You know, what is the deal? Just tell us, man. The judge is so frustrated already. We're 4 minutes in. You know, he's got this little tell he does with his mouth. He tightens his lips, and that's when you know his blood is boiling.
With you on that. I completely agree with you on that. And the case law is clear that if even there's a scintilla of evidence, I have to give that instruction. But we're not dealing with the jury instruction right now. What I'm dealing with right now is pretrial. The state saying you cannot proceed on battered spouse. There's two avenues in this motion. Avenue one is you cannot proceed with battered spouse because of the factual reasons based on Dr. Harper's deposition as to what she's going to be the basis of her opinion. Battered spouse cannot be entered. Alternatively, you cannot talk about it until there's foundation. That's my takeaway from the state's argument, that before battered spouse is argued or provided or opinion, there has to be that foundation to it. And the linchpin for me is the overt act issue. That how can we have anybody testify to opinions or any of the reputation or specific instances of conduct that we permitted until that overt act is established? What's your response to that?
My response to that, if I'm understanding you correctly.
And if you need to reframe the question, please.
Because it's procedurally. There's no way that we could come in here and put Dr. Harper on the stand before Sarah Boone. It just doesn't work. Because to even establish the relevancy of Dr. Harper's testimony, Sarah Boone, who's the only witness there at the time, I agree with that with the state, has to present evidence of.
He's talking like he's got a whole pork chop in his mouth. Like, oh, I hope he doesn't have like a speech issue. I don't want to make fun of that if that's the case, but has he got his mouth full of potato salad or what?
Self-defense. Has to present the evidence of the court talking about that overt act. It's not based on what the doctor perceives or what the doctor was told by Miss Boone or what questions were asked at that deposition. I don't know. Mr. Owens took the deposition. The questions, though, at the depositions are limited, and the doctor answered.
Did this guy narrate for those really old Disney movies? Like The Fox and the Hound, where the narrator reads an introduction at the beginning. You remember those old Disney movies? He's got the voice for it. I can see the film in my mind if you listen to this guy's voice.
But that's not what this has to be based on. What it has to be based on is what does Ms. Boone, in this case, testifies to on the stand. And if any of that, excuse me, if any.
What was that, man? Have a Strepsil. Okay, you're going to be talking. Clear your throat. Remove that fucking chicken bone.
Of that presents a scintilla of evidence to award the self-defense instruction, then the self-defense instruction should be given. That's the first step. Everything follows after that, Judge, because this isn't a situation where I think it's appropriate to make a pretrial ruling, because the ruling has to be based on the evidence that comes from that witness stand. Now, any of the evidence is subject to cross-examination, impeachment, anything like that. But that's a wait for the jury to determine. But as to the admissibility of the evidence, it has to start with Sarah Boone. A judgment can't be made or a decision cannot be made until the testimony of Sarah Boone takes place at trial. This is just procedurally incorrect.
This judge is so he's on the verge of quitting, isn't he? He's like, how old is the judge, do you think? He's probably 55-ish. So he's got probably, he could stay on the bench for another 5, 8, 10 years and then retire. But, he could just retire right now, hang up his robe. He's got the money, hasn't he? He's probably loaded. Is it worth it, Judge Kranick? Why don't you buy yourself a nice, small passenger plane? Not a jumbo jet, maybe just a Boeing. What is it? 707? Something, something basic, and just fly around in that. Go and see John Travolta. He's got his own little miniature airport on the side of his house.
Any other arguments, sir?
No other argument.
Thank you. Rebuttal.
This is procedurally correct. Parties are allowed to get motions in limine based on the proffers of evidence that have been made prior to trial. Apparently, opposing counsel has not read the depositions, or he clearly didn't
George
attend them.
Foreman, yes, Vivian, that's it. The lean What is it? The lean, mean grilling machine. That's exactly right.
Because he was not there. But the court has before it the statements that Sarah Boone made when directly asked, what happened that day? What happened next? And there was no overt act taken by the decedent on that particular day. What they want to do, and what is not permissible under the case law that I've cited, in particular the one that says you get a threatening text and then 2 days later you can't go slit somebody's throat because of the threatening text 2 days earlier. Not to dehumanize Mr. Torres at all, but to give you this analogy. If somebody owns a bad dog and that bad dog bites and that bad dog is bitten in the past, but on this particular day, the dog is just doing arts and crafts and puzzles and hanging out, drinking some Woodbridge Chardonnay.
I like the sound of this dog he's describing. The dog is just doing arts and crafts, hanging out, drinking some Woodbridge Chardonnay. He only likes Woodbridge, okay? This is a dog he's talking about. Hey, Soap, what do you think about that? Would you like Woodbridge Chardonnay or something a little more upmarket? How about arts and crafts? Puzzles? Maybe I'm going to get Soap a puzzle for Christmas.
And you put the dog in the suitcase, and then
Okay, part of the reason I like listening to court so much is for sentences like this, right? Have we departed from all sane thinking here, or what? If you put the dog in the suitcase, where else are you going to hear a sentence like that? I mean, if the dog is drinking some Woodbridge Chardonnay and you put the dog in a suitcase, that's never going to come up anywhere apart from a Florida courtroom. Okay.
and the dog barks because it's in the suitcase and doesn't want to be in the suitcase when it's zipped up. That triggers you to, I remember when the dog bit me in the past. You can't, that's not how this works. That's not how self-defense works with or without battered spouse syndrome. There has to be an overt act. You can't bootstrap and make up a fictitious act of violence on that day based on the past violence. That's not what the case law allows. And the state is asking, unless they are saying that the testimony will be different at trial, we are asking for the court to prevent them from saying anything about this during opening statements, because they will know based on the court's ruling what your client has already said to Doctors Werner and Harper does not admit self-defense evidence into this case. So that's what we're looking for, is that ruling. If this is what the testimony is at trial, then self-defense is not going to apply, and all the ancillary prejudicial things that come with it, reputation evidence, past instances of violence, battered spouse evidence, is not coming in either. Now, if they make...
Okay, we got a little review here for Woodbridge Chardonnay, okay? Where is it? Wine description. Lush, ripe pear, peach, and aromatic baked apple expression with hints of flowers and vanilla oak spices. Crisp pippin apple finish turns creamy as it lingers, with an aroma of green apple and a floral undertone. Our Woodbridge Chardonnay displays a smooth elegance. The aromas and flavors show nuances of baked apple and cinnamon, ending in a rich oak finish. I bet they called it apple pie. We need a couple more bottles of apple pie. So I don't believe I've heard of Woodbridge wine before by Robert Mondavi. Is that a piece of shit? I guess it's a piece of shit, right? 3.4 out of 5. are their customer ratings. Cheap and mean.
Some statements and promises that they cannot fulfill in opening statements, then that'll be on them. King versus State will allow us to point those
Angel baby, welcome.
things out to the jury, and it will not be burden shifting. But that's what we're asking is, this is a proffer, just like any other proffer testimony, like a sex crimes case, where we file a deposition of a Williams Rule victim and ask the court to rule prior to trial, hey, if this is how the Williams Rule victim testifies, and it's clear and convincing, and it meets all the standards under 404 and 403, can this prior act of sexual violence come in during the trial? This is what parties do all the time, is get pretrial rulings on crucial matters like this. This is a crucial matter because the tip of the iceberg is the second-degree murder. The rest of the iceberg, the 99% of what has been going on for the last month and a half, is the self-defense that just isn't there. It wasn't there under her former statements to the police, and it's not there under her current statements. So we're asking for a ruling, a motion in limine, which is subject to change based on the evidence at trial. But if this is what the evidence is at trial, the court should not allow any of the battered spouse, any of the prior violence, any reputation evidence in. That's all we're asking for.
Okay.
Thank you.
All right. Thank you.
Judge, can I respond?
Briefly.
Briefly, because I don't think, I'm ready to side with the prosecutor. So, you've got 3 words, and they better not be anything to do with barbecue. Okay. I'm not coming to your cookout. Okay. I'm not interested if you've just purchased the Smokemaster 3000. I don't want to know. You're not going to win me over with some baby back ribs. Okay. I am a judge.
Judge, it is not the responsibility of the defense to present their case at a pretrial hearing. However,
But the problem is in the state's argument, in the case law, which the case law has been presented by the defense in your filings, are not germane to the issue. We're not addressing jury selection and the standard of proof and the burden with regard to self-defense, you establishing a prima facie case, and then the higher standard that the state has to overcome it. There's no dispute as to that. The issue is the necessary predicate to establish battered spouse. And the state's argument is that due to the lack of an overt act.
When Mr. Owens finally came on and took over the case for Sarah, the judge must have thought, oh, brilliant. Okay, finally. I'm not going to have to do a lot of explaining, and we've got someone who at least knows what they're doing. And then he brought in this guy, and the judge must be thinking, this would have been easier with Sarah representing herself. He can't catch a break, this judge. What did he do in his past life to deserve this? To sit on this case with these people?
Based on what Dr. Harper has relied upon, to wit, the multiple interviews or sessions with Ms. Boone, that element seemingly is lacking. We all know what elements are, right?
Hi, Jane. How are you doing?
If it's a negligence case, it's duty breach causation. In this case, it's the elements based on the jury instructions are George Torres is dead, she caused the death, and it was done so in a depraved heart manner. I may have butchered that last element, but those are the elements that need to be established based on the jury instructions. Similarly with self-defense, the case law talks about the overt act.
yes.
And then the flashpoint of the defense's argument is that the facts which were provided to the expert, who in turn will testify to battered spouse, that flashpoint, that overt act is lacking.
It's not, Judge, but I find myself in the position now to disclose what our view of the overt act.
It's not, Judge. It's not lacking. We just haven't told you what it is. Okay? You're going to have to wait for that, Judge. It's not lacking. Who does he think he is? The judge has just told him it's lacking. The overt act hasn't been mentioned. And the guy says it's not lacking. I know that I haven't introduced it, but it's here. It's just a secret right now.
Act is.
Okay.
That's what this is what this motion has put us into. So it's an exercise of the state to learn our theory or our view of the evidence, because the overt act is in the physical evidence. And the overt act is mentioned to Dr. Harper in the deposition as to the reaction of Miss Boone by the overt act. And the overt acts, I have to tell you, his hand is coming out of the suitcase. That means he's about to get out of the suitcase.
Really? Because we saw the video and there was no even two fingers. Never mind our hand coming out of the suitcase. I mean, the hand was coming out of the suitcase invisibly. You know, not shown at all on the video.
Now, based on history and everything else, she doesn't have to wait to see what's going to happen when he gets out of the suitcase. It's clear what's going to happen when he gets out of the suitcase. It's followed up by physical evidence, because there's a picture provided of Mr. Torres's hand that shows a mark on that hand that it matches up with the bat. That's
What do you mean it matches up with the bat? Like, you don't get a mark on your hand from holding a bat. You get a mark on your hand when it's been hit with a bat by Sarah. You know, she beat him in that fucking bag with a baseball bat, didn't she? Like a piñata. Put him in the bag, beat him with a baseball bat in the bag, threw the bag down the stairs with him in it, knocked him out cold, filmed him when he woke up, freaking out with claustrophobia in positional asphyxiation. I mean, that's just a terrifying combination of words, isn't it? Positional asphyxiation. And went to bed. What is the overt act?
the overt act. It's like a gun, okay? You don't have to wait for
Thank God she didn't have a gun, for fuck's sake.
them to pull the trigger. You don't. And it's based on
You don't have to wait for them to pull the trigger, but you do have to wait for them to point it at you and threaten to pull the trigger. I mean, that would be an example of an overt act, okay? Jesus Christ.
on all the evidence in the case, just not testimony, but also physical evidence that might support the testimony.
Thank you, sir. All right, the court has had the opportunity to review the motions, review all the case law. The state's motion is going to be granted in part and denied in part. With regard to the state's request to exclude battered spouse syndrome evidence outright, the motion is denied. As to specifically Wagner, for the reasons identified in the court's prior rulings as to the concept of argument, again, there's no outright evidence
Hello, Amanda.
of accident, not argument, excuse me. As to the state's reliance on Lantz, L-A-N-T-Z v. State, 263 Southern 3rd, 279, no argument of self-defense was ever offered in that case. I find the cases of Reed v. State, 213 Southern 3rd, 1110, Rudin, R-U-D-I-N v. State, 182 Southern 3rd, 724, State v. Woodson, 349 Southern 3rd, 510, and Morris, 325 Southern 3rd, 1009, distinguishable as all of those cases were traveling under 776.032 for stand your ground hearings.
Hey, Carrie B. Carrie B says you can't have surprises in trial, which is what they want to do. They want Sarah to testify to something she's never said before, and then the lawyers are left to clean up that mess. Well, okay, that seems to be a general outline of what's going on in this motions hearing. But what about Charlie Adelson's trial? Because that was they kept his defense to themselves and didn't inform the prosecution. They only have informed the prosecution of the outline of their defense in Rashbaum's opening statement to the jury. Remember? He said, they're about to find out, like all of you, what really happened. He was extorted for the money. You know. So is that a county issue or what? Because why was Charlie Adelson's trial allowed to have the defense kept to themselves? I seem to remember another element that was involved there, but I can't remember what it was.
It's undisputable that an overt act needs to be provided under the Holland case by the Florida Supreme Court, 916 Southern 2nd 750. I find the departure from the essential requirements of law argument by the state factually and legally distinguishable, as there was a specific statute for the state obtaining medical records as relied upon in Roberts v. State by the 6th DCA in May of 2023 WL 3262633 at Pinpoint Site 2. So for those reasons, the state outright motion to preclude or exclude battered spouse syndrome evidence in toto is denied. With regard to the second portion, that excluding mention of battered spouse syndrome evidence until there's a basis for it.
See you soon, Amanda, and thanks so much for the coffee. Just saw that come in. Hey, if anyone else would like to support the channel, remember that we are accepting coffees on buymeacoffee.com. There's a link in the description where you can help support the channel and buyusacoffee.com. We are also now accepting super chats and super likes and super stickers on the YouTubes, as well as our fantastic Patreon community memberships, guys, and memberships on buymeacoffee.com. We've got fantastic memberships: Addicted, Obsessed, Possessed, and Life Without Parole, lifetime access to fabulous coffee membership benefits, as well as our fantastic merch store. Where is the merch store? Beautiful, fantastic True Crime Metrix merch. Yeah, check that out. We've got hoodies, we got logos, we got Judge Everett, we got what else have we got? Charlie Adelson quotes, we got pillows, we got Judge Everett blankets, mugs, stickers. You're either stupid or you're lying. I mean, what a fantastic shirt to wear on any occasion. Range of colors. What else have we got? More to come, guys. We've got such a long list of merch to get through. It's not even funny. Where will we find the time? Yeah, going all the way back to Don't Be an Adelson merch. Check that out. Stickers for Don't Be an Adelson merch. Look at that. You could get that sticker right now and stick it on something that you own. And then your thing that you own would be an Adelson product. Fantastic stuff. But the best place, as always, is buymeacoffee.com. Link in the description. Help support the channel. And thank you very much. And like the video, share, subscribe, leave a comment. And yeah. Good to see you all here. Let's go back to the show. Oh.
In Medina, specifically that there needs to be testimony provided for the expert to testify to the battered spouse syndrome, and there needs to be sufficient predicate established for that self-defense. So I'm going to preclude any mention or testimony in the form of expert testimony as to battered spouse until that necessary predicate as identified in LAD 564 Southern 2nd 587 has been established. Any questions with regard to the state's ruling? I'm sorry, the court's ruling, forgive me. Defense.
Meaning,
You want to mention an opening? You can mention an opening. Certainly, I'm going to allow you in the state.
Meaning, I mean, this guy just doesn't really seem to be able to grasp whatever is going on. He hasn't really understood a single element of the discussion so far. I mean, where did they find him? Why isn't Mr. Owens handling this? You know, surely he's lead counsel. Why? I don't even know who this guy is. This is the first time I've seen the guy in the blue suit. I don't even know his name. Has he said his name? He hasn't even introduced himself. There's been no notice of this as far as I'm aware. He's just shown up. The way I understood it, Mr. Owens was going to have two paralegals. I think one of whom has recently passed the Florida bar, but new and young females assisting with the case. Suddenly, there's this other guy who really needs things explaining to him that he should be able to grasp. You know, I'm not sure what's going on.
At this point, has no problem with the concept of battered spouse being addressed in voir dire. And even if the state objected to it, I most likely would overrule it based on.
Yeah, Neverly, he looks good in the suit. That is I mean, the sleeve here looks a little short, but I think it's just a little creased at the top. But it's a brand new suit. That's off the rack, you know. But you know, it's a good combo as well. He looks great in the suit. It's a fine suit. The watch looks nice too. So look at his watch. What is that? A Casio? Okay. Yeah, but as far as, you know, good legal footing, he doesn't seem to be quite there.
On the litany of case law that you cited, that you're allowed to dive into those things during jury selection. As to should the defense put on a case, the predicate under LAD needs to be established before any expert opines to battered spouse.
My concern is open. Can it be mentioned in?
Yes.
My concern is opening. The judge has literally just said you can say it in opening. My concern is opening.
That's your decision. That is your decision if you want to mention an opening. There's no preclusion from you doing that. Okay. Any other questions with regard to the court's order on that matter? State.
No, Your Honor.
Defense.
No, Your Honor.
Okay, thank you. Moving now to the defendant's motion in limine filed October 6th and the state's response to same. It looks like we've reached some level of common ground with regard to that motion. The court is going to grant the motion with regard to the statements on page 69 through 71 of the transcript of the February 25, 2020 interview between Detectives Lowen and Counsel and Miss Boone from page 69, line 6 through page 71. That will be granted to the state not objecting to same. That leaves us to the statements on page 53, line 11, 53, line 13, line 14, page 55, line.
Hey, sorry, Carrie B. Did you leave a reply? Let me see. Let's go back to that right now, Carrie B. Much appreciated. Yeah, but Charlie's defense was I didn't do it. Sarah is wanting a self-defense. Totally different because the state has to approve it. Is that the difference, is it? Okay, let me think about that. So if Charlie is saying I didn't do it, so in Sarah's case, the key issues are introducing kind of character history evidence, like he was violent in the past, he's had these incidents with me before, he's been arrested before, and these things, right? So that's what the state is arguing against being allowed in if it can't be established that there was reasonable grounds for Sarah to be in fear of serious bodily harm or death at the moment that she needed to use the self-defense, right? So I see what you're saying, because if your defense, like Charlie, is simply "I didn't do it," that doesn't really call for those kind of additional evidence factors to be brought in, supporting evidence from the past. But I'm still a bit confused, because if Charlie's defense was kept secret, how would the state know? He could have said, "I did kill Professor Markel, but it was in self-defense." I mean, if it's a little confusing for me. But thanks for pointing that out, Kerry.
Line 24, page 56, line 1, and page 92, line 15. With that, defense, you may proceed with any argument. Similar to the last motions, I have reviewed all of y'all's case law.
I believe there's some state witnesses here. We would like to invoke them.
Okay.
The rule of sequestration applies to testimony of other witnesses, not to anything else.
Response?
Is there going to be testimony?
Not from the state.
You've got state witnesses here.
Look at Chicken Cacciatore's face. I mean, the guy looks constantly uncomfortable, right? When he's not spiking the vein. You know, how long has it been since his last fix? He's going through cold turkey right now. Look at that face. Look at that face. He's in pain. He's suffering. He needs some methadone. What time does the methadone clinic open, Chicken? Hold on to the desk. Look at him holding on to the desk. And this guy really doesn't like the defense, does he? Did you see the way that he didn't look at him when they're talking? He's looking straight ahead.
Not to anything else.
Response?
Is there going to be testimony?
Look, Mr. Owens is looking at him and he's looking straight ahead.
Not from the state.
You've got state witnesses here, you know. She's allowed to be here to watch. I understand, but I want to know whether she's going to testify.
I said there's no state witnesses.
So that's a no. May proceed with.
Is that what's her name? Chelsea, Officer Chelsea.
What's any argument?
Not from the state.
Response?
Applies to testimony of other witnesses, not to anything else.
Response?
Is there going to be testimony?
Is there going to be testimony?
Not from the state.
Not from the state.
You've got state witnesses here, you know.
You've got state witnesses here.
She's allowed to be here to watch. I
She's allowed to be here to watch.
understand, but I want to know whether she's going to testify.
I said there's no state witnesses.
So that's a no.
That is Officer Chelsea, isn't it? I can tell by the sour expression on her face. Someone needs to get that damn lemon out of her mouth. You know.
May proceed with any argument, Mr. Owens.
Can I approach the bench?
Yes, sir. I have reviewed the 2.8 instruction prior today. Thank you, Counselor.
Judge, the problem is the state attorney, when they filed the response, they didn't include the highlighted portion that's italicized at the beginning. Police opinions and statements regarding guilt are generally inadmissible and must be redacted from recordings introduced into evidence unless redaction would render the defendant's relevant admissions incomprehensible. If a recorded interview cannot be appropriately redacted, the trial judge must, upon request, give the following limiting instruction immediately before the recorded interview is played for the jury. That section, which is comments directed to the court, was not placed, to my understanding, in their response.
Okay. Any other argument?
Judge, this was a 2-hour interrogation that occurred the day or two after the event. And the day prior to this time, or that morning, the detectives uncovered the 2 videotapes, the 2-minute video that Sarah Boone had recorded, and then followed up 11 minutes later with a 22-second video that she recorded and they found on her phone, which I believe from the interrogation discloses that Sarah did not remember making those recordings. But the purpose of law enforcement's position about having her come in was to interrogate her in an attempt to get a confession from her to the murder. They spent 2 hours trying to do that any which way they possibly could.
That's not a very long interrogation, is it? I mean, 2 hours? What do you think it's going to be? 20 minutes?
Could. And the law says that they're allowed to use, and I cited several cases. I cited the Smith v. State case, the ODEH, O-D-E-H v. State case, and the Eugene v. State. And in those cases,
I didn't see a citation to Eugene. I mean, Eugene's included in ODA, but I don't,
Eugene is found, do you need the site?
I have it. It's included in ODA, but you did not cite it in your motion.
Okay. Eugene is 53 Southern 3rd, 1104. But law enforcement are entitled to use a variety of interrogation techniques to try to elicit a confession to the crime. But as in that case, in spite of the detective's efforts, Sarah Boone refused to admit that she was guilty of the murder. But as a last resort, Judge, and it was a 2-hour interrogation, it was the last portion, at least the last quarter, it may have been less than that, is when the detectives made some statements that are highly prejudicial to the defendant and tend to be opinion and tend to invade the province of the jury. And that's why this special jury instruction 2.8, recorded interview, effective law enforcement statements on the defendant, has that italicized portion in there. And the statements we're referring to under my motion, the second section of evidence to be excluded, page 53, line 11, well, he's dead as a result of your actions. And then paragraph 9, line 13, he's dead as a result of your actions. She responded, line 14, I understand that. And then paragraph 11, page 55, line 24, I have one last question. I mean, you realize you're the person that killed him, right? Sarah Boone responds on page 56, I thought about that. And then lastly on page 92, well, intention or not, here's the detective distinguishing how he interprets the law and her culpability. Well, intention or not, George is dead, and you act like when you say unintentionally, that absolves you from everything. That is exactly the kind of opinion testimony from law enforcement that the courts are worried about. The probative value of that type of opinion testimony about her guilt is outweighed by the prejudicial effect. Thank you.
Response.
State stands by the case law that we cited and that the jury instruction that would be read. I didn't feel it necessary to include italicized portions of comments to the court because this is what would get read to the jury. Those statements are designed to get responses from her. They did get responses from her.
Let me ask this question first, Mr. J. Do you disagree with counsel's representation of what is reflected in the Q&A at that point in time?
To the extent that he is making the argument that they're expressing an opinion about the
No. The words, not his opinion, not his thoughts or what it means, but the black and white verbiage.
Who's muted? Am I muted? I don't think so.
Is reflected in the motion. Is that what's reflected in the recording?
I'm accepting that he would not misrepresent that to the court.
Okay, thank you. You may continue.
And as far as the last line on page 92, line 15, if something's designed to get a response that a normal person would respond to and there's no response, that still makes it a relevant statement. He's not giving an opinion on the law. He's giving an opinion about her reactions.
Thanks for letting us know, Benton, and sorry you're having trouble, Colleen. Is anyone else having trouble? I think it's pretty smooth from this end.
To this interview and trying to get a reaction from her when he says, well, intention or not, Jorge is dead. You act like when you say unintentionally.
You crazy, Vivian. No one's going to block you. You're one of our star players on this team, Vivian.
That absolves you from everything. He's not stating that that is a legal defense. He's just commenting on what has transpired in the 92 pages of the interview. So we defer to whatever the court's ruling is.
Okay, thank you. Any rebuttal?
Just for the state attorney not to put that in there, the italicized portion where Supreme Court is giving instructions to the court with those comments, for them not to put that in there, I disagree with.
Okay, well, the Jackson case speaks for itself, and the court has reviewed it.
Thank you.
All right, thank you both for your motion, your motions, your responses, and the case law. The court is going to grant the defense's motion. I disagree with the defense, or with the state rather, as identified in their response, that the only issue is battered spouse. The issue is one of the elements is cause, and those three statements go specifically, I believe, to opinions as to the cause of Mr. Torres's death. So the court is going to grant the state's motion, as under the Bush case cited by the state, law enforcement's opinions are inadmissible due to the prejudicial effect that they may have. And I do find that this is the expression of law enforcement's opinions as to the guilt of the accused. As such, the motion is granted, and those will need to be redacted from. I apologize. Thank you. The defense's motion is granted for those reasons. Any questions or clarifications with regard to the court's ruling? State. Questions or clarifications with regards to the court's ruling? Questions or clarifications with regard to the state's ruling? Or the court's ruling, excuse me. All right, that takes us now to...
See, the pressure's getting to the judge. He's calling the state the defense, the court the state, and just there's been about 6 fuck-ups like that so far.
To the state's objection and motion in limine to exclude decedent's.
I think her outfit is horrible, Amy. What is with this blouse thing? What is this? She looks like a priest. Yes, I know. I'll dress like a priest because a priest wouldn't be found guilty of second-degree murder. She's just missing the dog collar.
Medical records. I've reviewed that as well. State, you may proceed.
Just the other night, I received 550 pages of medical records regarding the treatment of Mr. Torres from 2 incidents, one in 2017 and one in 2018.
Bearing in mind, that's probably the nicest jacket Sarah Boone has ever worn that she didn't steal from the cloakroom at the club, saying, yeah, I lost my ticket, but I can see it. That's mine right there. That's mine. I see it. That's, yeah, I came in with that. You know?
Email that I received from Mr. Owens purported he believed that they had attachments. They did not. I replied to him as such, and I have not gotten any additional emails with attachments regarding the medical records. So for the purposes of this hearing, all I'm arguing about is the 550 pages that I have been provided. One of those instances involved a narrative being given by the patient, Mr. Torres, that he had put his hand through a plate glass window.
This is the 2018 incident, correct?
Yes.
Yes.
And his wife, the following.
Yeah, 2 years before he broke a window. I mean, it must have been a pretty weak window.
Day made him go in and get treatment. There was a 4.5 centimeter laceration. that require 2 sutures. There is no history in the narrative about any violence that the decedent had committed. So I anticipate that Ms. Boone, when she testifies, will give us an explanation about how this was an instance of past violence that she was aware of by the decedent.
Gift memberships, guys. We have had gift memberships before, and I haven't switched anything off. Let's see if I can have a look at the settings right now.
Decedent. So making that assumption, then what the state is asking for is the 57 pages seems excessive. This jury is going to have a lot of information to weigh and consider. Not every page of these 57 pages is relevant. What is relevant is, yes, he came in for treatment, that narrative, and the history that he gave of putting his hand through a plate glass window and that he got sutures, that corroborates her testimony. I understand why she will need corroboration for her testimony to bolster her credibility. So if she testifies that way, we get it, but it's just excessive and it's going to be confusing. They don't need to read 57 pages of all of his treatment. The second batch was 400.
Oh, I was just going to share a screenshot, but are we sharing this tab now? Oh, no, not this one. Hang on. Yeah. So it appears there are gift memberships, right, on desktop. So you go to the $, and then there's super stickers, super chat, memberships, or membership gifting. And then there they all are like that. So it appears to be enabled. Yeah. But all great ways to support the channel, guys, as well as the fantastic one and only buymeacoffee.com. Link in the description, guys. Oh, lost audio, I think. Hang on, chicken.
An incident on Christmas of 2017 when what the decedent reports in the narrative
Thanks so much, Vivian, for the super sticker.
to the hospital is that some unknown men jumped him and beat him up. Being a victim of violence is not relevant in this case. I expect there will be a story based upon the testimony that we've taken from the experts that this all happened at a family gathering and one of the decedent's brothers learned from Sarah Boone that Sarah Boone said that the decedent, had committed violence against her and then beat him up. That's not the same ilk as corroborating violence with breaking windows or whatever it is that caused his laceration, whatever she ends up testifying to about the 2018 incident. But this incident, it's irrelevant that he got beat up by his brother.
Yeah, Beth, memberships are random. So if someone buys a number of memberships for gifted memberships, they go to random people that are in the stream right now. But you can pick up one yourself, Beth, if you want membership. That it's not very much of a cost.
It's irrelevant that he suffered the amount and severity of injuries that he did. That is not required to corroborate her testimony that, I don't even know if it comes in, that she makes an out-of-court statement to the decedent's brother that something is true that happened in the past. That seems like classic hearsay. I'm not sure how she would get that in.
No, Mary, it's just if you're in the stream and someone buys gifted memberships, they go to random individuals in the stream.
I don't know that the 487 pages is needed to corroborate that. And if the court, like I stated in my response, if the court believes that it is necessary to corroborate her story that he did get beat up by his brother, then again, there are narrative parts of these medical records. Generally, I would say in this particular instance, it was a handful of pages that give the narrative as to what happened. And I don't know that it's relevant what the treatment was that he received, but there's narratives of that as well. They don't need to be bogged down with 487 pages of toxicology reports, nursing rounds, just all the things that I'm sure the court is familiar with from your past experience that are in these medical records. It's unnecessary and it's prejudicial. Its probative value is substantially outweighed by its prejudice, confusing, repetitiveness, as I outlined in my response. So that's our position.
Thank you, sir. Response.
Judge, as you know, we got on this case about 45 days ago, and I can't tell you how many pages.
He keeps going on about this, like, we got on this case 45. That was the deal, man. You knew that coming in. It's, if you thought it was too much, you shouldn't have signed up.
Of discovery there is that we've had to go through. And 2 or 3 weeks ago, the state attorney provided us over 500 pages from either telephone calls that my client was involved in from the jail or tablet communications, which are kind of like email.
Sorry for so many of my interruptions, guys, but I feel like I should read this one out from Neverly Darling because I've given the wrong information. Apparently, if you want to be able to receive a gifted membership, if some kind contributor wants to buy a bundle for the viewers, you do need to have something enabled in settings in order to be able to receive the membership gift. So I may have been wrong on that. This is all getting a bit complicated, isn't it?
Emails or text messages, and that hasn't been narrowed down, but that was given to us. So that's something else we had to stop and go through over 500 pages, and they haven't narrowed that down to which ones they believe are incriminating to her.
Understood. But respectfully, that's not the issue before the
I
court right
understand
now.
that. But yes, the medical records are going to be narrowed down. And yes, we would have to make some tie
Hello, Anne. How you doing? Good to see you.
to Sarah Boone's testimony to whether or not their medical records of the decedent, George Torres, are admissible to corroborate her stories about the incidences of violence and whether they match up. But yes, I agree there's going to be a narrowing down, but it's kind of premature about that. They've got several volumes. I assume before they introduce something, they're going to have to narrow it down. Did y'all not have George Torres's medical?
There you go. That's summed up real nicely, Colleen. Apparently, if you want to be able to receive gifted memberships, if some kind individual wants to buy a bundle for the group, you go to the join button and go to the gift settings and slide the toggle to on. Thanks, Colleen, for that succinct, clear instruction. Much appreciated.
medical records prior to me sending them to you? All right, well, we took the deposition of Dr. Harper, and as you know, Judge, these forensic psychologists, when they're trying to make an opinion as to battered spouse or whatever the case may be, they rely on their assessment involving the personal contact and interviews they have with the client, but a lot of it is any other collateral evidence that tends to support it. That involves arrest reports, that involves court records, that involves psychological notes, that involves medical records. And at that time, when the state took Dr. Harper, our witness's deposition, she said, yes, I did rely on George Torres's medical records. So they were well aware.
That doesn't mean they come into evidence.
I know that. I didn't say that, but they were well aware that that's one thing that she relied upon. A lot of that collateral evidence doesn't come into, and it's going to be.
I need to jump into the breach here. I understand all of that. I understand that there's been volumes of documents that have been provided between both parties. And I understand, based on my review of the highlighted portions that the state pointed out in their motion, as to what Dr. Harper relied upon. None of that is germane to the state's argument.
Oh, you met Amber Heard, Anne. That's interesting. I wonder what that was like. Was she drunk?
And you've admitted that there needs to be a narrowing down. So let's just kind of compartmentalize what we've got here.
So it's premature. It's premature. I agree it needs to be narrowed down. And then based on Sarah Boone's testimony.
You are the proponent of the evidence. So you have to establish relevance.
I agree.
And you have to establish that it is not so substantially unfairly prejudicial.
Yes.
That the prejudice does not outweigh its probative value, including but not limited to the other identifications in 90.403.
Yes, sir.
So my question is, sir, with regard to the 2018 incident of the fist through the plate glass window, and I can't recall 40 some odd pages, I think the state identified as that. What of those 47 pages is germane to an incident of violence that may be needed to establish the self-defense concept of those 47 pages?
It will be relevant after she testifies about that incident.
All 47 pages?
Well, I hope your friend got out of there in one piece, Anne. You know, I don't know if Johnny Depp will ever be the same again.
Pages?
Maybe not all 47 pages. I've agreed that some of it needs to be narrowed down.
Okay, well, what of it needs to be narrowed down? Since
Well,
we have some level of common ground here.
My case is not going to be presented, I would assume, until next week. So I've got a little bit of time. I'll let the state know.
That's not how this works.
Okay. I can't let you know today.
We should really go back and at least cover some of the primary highlights of the Depp Heard trial, huh? I mean, there's some great things to work with there. Not just for shits and giggles, but you know, there's some stellar legal work from Brown and Rudnick, Camille Vasquez, Mr. Chu. That other guy was very good as well. You know, it's a showcase of what kind of legal defense or representation you can have if you say, I don't care what it's going to cost. You know, it's a pretty good example of that, huh?
Today, Judge, I'll narrow it down, or we'll talk in the next couple of days.
Well,
by
the state's
Friday.
position is that the narrative should be permitted as to the 2018 incident, the why Mr. Torres was there. But the nursing rounds, the charts, the follow-ups, treatment, anything in the...
Is the expression not shits and giggles? Is it supposed to be kicks and giggles? Is there an expression? I don't know. In my mind, there's an expression, and it's shits and giggles. But I'm not certain now. Anne, you're causing me to self-doubt.
the future, other than the 4.5 centimeter laceration that required 2 sutures. I understand the narrative as to what transpired. What else is relevant? And I haven't seen these 47 pages, so I'm not sure there. I'm relying on counsel's representation.
I don't know. I'd have to look at them, but in one of the medical records, George Torres was over a 0.31 BA.
This is a very interesting proposition or question or whatever it is, Derek. Who wins the showdown between Camille and Georgia? Well, I suppose that would depend on who their audience is. Like, for example, if it were a Tallahassee jury, Georgia's home turf, I'm not sure Camille Vasquez's style is appropriate for that audience. Georgia's really, really is. but in a different setting. I mean, they're both very good, very different styles. Georgia's slow and methodical, and you know, that lots of other things as well, but strong. And Camille Vasquez is obviously very strong. But Camille particularly worked against Amber. You know, how would Georgia Kappelman do against if the game was to cross-examine Amber Heard? I'd say Camille Vasquez is better for the job. But in other scenarios, I'd say Georgia's better for the job. To be honest, I don't know if it's really that much of a fair comparison to say who would win. We'd have to come up with a way that could be judged fairly. They're both very good. I think personally for me that I enjoy watching Georgia more than Camille. Or I enjoy watching Camille very much. I think I would get along better personally with Georgia. I think we'd have more fun, you know, at the Tallahassee annual pig race or whatever we were doing that weekend. You know, I really think I'd get on with Georgia. I'm not sure that I would have the same chemistry with Camille myself, but that's just personal.
AC. Every
In
time,
2018?
2008.
I'm talking about the 2018 incident with regard to the plate
I
glass
have to look at
window.
the records, but there is other evidence in those records that's going to be relevant after she testifies. That's when she gets beaten, when he gets really drunk. Or that's when he does something violent or threatens to do something violent when he gets really drunk. In one of those incidences, he was over a 0.3. When he gets over a 0.2 to 0.3, that's when he gets angry. He's fine.
Over a 0.3. That's practically 4 times the limit for driving. That's pretty drunk, right?
Up until that point, we're going to establish that. I don't want to put on my defense today, but Judge, there is going to be relevance to more than just the narrative of those medical records. I'll narrow it down by Friday. That's the best I can do.
Okay, what about the 2017 incident, 487 pages, and those documents pertaining to the facial reconstruction and anything thereafter? What does that have to do with anything?
Same thing. You know, it's going to be based on her testimony, and then the judge is going to have to make a decision about whether that's admissible based on her testimony about what happened.
But what does the facial reconstruction, surgery, pre-surgery, post-surgery notes have anything to do with whether or not that incident actually took place?
That's going to depend on Sarah Boone, depending on what her testimony is, and you'll have to find based on that whether or not that's relevant and probative to the case.
That's not how motions in limine work.
I don't know what else to tell you, Judge. She's going to have to testify, and then we'll make the arguments as to the admissibility of that.
I'm struggling with understanding how I can understand BAC results. I can understand that based on Dr. Harper's deposition. I can understand the narrative as to why they were there.
You got me thinking, C. Malone. Maybe we should come up with a new Southern style recipe. Creamed corn with Skittles just thrown into the mix. You know, they'd slightly melt down over time, and then you'd have all the flavors of the rainbow in your creamed corn. You know, a certain percentage of the population are going to love that.
I don't know what are all in these records. What does nursing rounds or pre-op, post-op of facial reconstruction surgery have anything to do with an incident that purportedly took place on December 24th, 2017? How is it relevant?
Some of those may not be. Some of the records may be relevant, depending on Sarah Boone's testimony about how what happened to him was tied to what he did to her.
Okay. Anything else?
That's it.
Response.
The two parties' discovery responsibilities in a criminal matter are not equal. The state of Florida has a duty to disclose anything.
You think Sarah's starting to think, man, I should have taken that deal. I would have only been in for another 10 years and I'd probably be out in 8 with good behavior. I should have taken that deal. That was a sweet deal. You know, Mr. Owens has dropped the ball again, and he's brought in this guy that he found in the bus station to be his co-counsel.
That anybody knows or may reasonably be calculated to lead to relevant information to the defense. The defendant's obligation is to let us know what they're going to use in trial. So for them to come in today on the 3rd day of jury selection and to tell us that it's premature to ask for what is going to be their actual evidence in a trial is wrong. They got these records, and I understand.
Yeah, right, Veronica. I see what you're saying. A creepy, chubby Jodie Foster. Chunky Foster.
And that they're the 9th set of attorneys for Miss Boone, but the defendant got these records in 2022 or 2021. And they just get disclosed to me overnight a couple of nights ago. In their discovery responses, in the First Amendment, Second Amendment, Third, so on and so forth, for weeks they were telling us that they didn't have them and they were waiting for them, but they were sitting in Miss Boone's box, apparently, that Billy Lane had acquired years ago. So it's not premature to ask, and it's not unfair to ask for what is going to be introduced in this case, or attempted to be introduced, particularly given the court's rulings. We had rulings from this court, I think you entered it August 5th or August 6th, setting forth a schedule for what are you both, and the state too, we both disclosed what are we actually introducing. The state has actually narrowed down the digital phone evidence from the defendant greatly to about 160 pages of the PDF from the thousands that it was, and handful and a few dozen pictures and videos. We have done everything we can to narrow it down. We're not asking for much here. We're not asking for much. And just to bring the point about the BAC, Jorge Torres had a 342 medical blood, so there's probably some conversion, 10-15% for legal blood, at the time that he was admitted for his facial injuries. That would be a different picture than on the date of the plate glass window. On that date, again, I expect that the testimony from the defendant will be that he was the aggressor, the violent one, and his blood alcohol level would be relevant for the plate glass window one. But I'm struggling to understand what his BAC's relevance is if we're all at a family gathering at the Torres's and she says something that triggers one of his brothers to violently beat him nearly to death, what his BAC's relevance is on that particular occasion, unless her testimony is the decedent was being violent with her that day. And that's just not my understanding of how the deposition's read. So, Judge, we're not asking for much. I don't think Friday's sufficient. We're attaching jeopardy to this case as soon as we swear this panel in, hopefully tomorrow morning. Thank you.
Thank you. All right. The court has reviewed the motion and has reviewed both the arguments. I'm struggling with the relevance on some of these things. So I'm going to grant the state's motion in part to the factual narratives as to why Mr. Torres was seeking treatment. That will be admissible. I'm going to overrule the state's objection with that, and I think they've conceded that that is relevant. Information regarding blood alcohol content in both the December 24, 2017 incident and the 2018 incident, I find potential relevance. So I'm going to overrule the state's objection with regard to those. However, the balance, I'm going to sustain the state's objection and grant their motion in limine unless there's evidence provided in the defense's case in chief that make these other documents relevant. Because at this point in time, it is unclear to me how the balance of other hospital records, nursing rounds, pre-op, post-op, the surgery itself from the 2017 incident are relevant to a fact of consequence, be it any of the material allegations the state needs to establish or any material allegations the defense needs to establish for the purposes of self-defense.
Yes.
I'm not foreclosing you, but there needs to be something for you to link these documents together for me. All right. Any clarification or questions with regard to the state's rule or the court's ruling? Defense. All right. Thank you. That now takes us to the objections to the evidence. Give me a moment.
Is it just me, or does it seem like the defense and Mr. Owens and co don't really have their ducks in a row at all on the eve of statements, opening statements? You know, they haven't completed their own theory of defense. Talk about winging it. What are you going to say? We don't have an overt act. We can't link these 6-year-old pre-op medical records about when George put his hand through a window, his tiny little thin wrist hand.
We have the defendant's objections to state's digital exhibits filed October 15th. The state's state's response to defendant's 5th amended reciprocal discovery exhibit list filed also on October 15th. I have reviewed these. I'm a little bit of a loss in the state's response because I don't know what items 1, 2, et cetera are. It just identifies them. I'm not sure what it is that they are.
It's tracking their 5th amended exhibit list. As I pointed out before, it got really confusing because as they added things, it would not go to the end of the list. It would get put into the middle of the list. So I started over, scrapped my first response to the first amended one, scrapped my second response to the second amended one, both of which were filed on September 27th in a timely manner. And this is why my paragraphs start with 0 in my response, because they have a paragraph 1A, and then they list the items, and I wanted to make it very easy and clear for the court to just be able to flip to what paragraph I'm talking about for each item, tracking their 5th amended exhibit list.
But here's the problem that I'm having. On September 27th, I see the notice of provision of defendant's 3rd amended exhibit list. When was the 5th amended exhibit list provided?
That might be a problem with them not filing things with the clerk of the court.
Okay.
I'm getting copies of some pleadings, but they're not bait stamped with the clerk of the court's e-filing system on the top left. So I'm not certain that they've filed anything with the clerk of the court.
Here's the other problem that I have. All I see on my end is the notice of providing. It doesn't identify anything. It's a 1-page document. So it's hard for me to say what, I know you may have seen it, but the court hasn't seen it based on what's been filed.
I believe I would direct any questions about why that's not filed with the clerk of the court to the defense.
Okay. All right. I need clarification, Mr. Owens, as to when the 5th amended reciprocal discovery exhibit list was filed and what is in it. Because the notice that I see in the court file from September 27th is just a notice. It doesn't identify anything for me to line up item 1 and item 1 as to what they purport to be.
You're asking for when it was filed? We're checking on that. When it was filed, what was the next question?
All I have is a notice. So on September 27th, there was a notice of provision of defendant's 3rd amended exhibit list. And it's just that. What we intend on utilizing has been provided. But I don't have anything else as to what those items are.
Okay. Did you want us to provide you with a copy of those to your JA?
Or you can send it to Madam Clerk and she can print it out to me, because I'm having difficulty lining up what these things are, because all I have in the court file is this was sent on this day, but I don't know what any of these things are.
We can move on to something else and let me get
we've got some housekeeping matters to address for this afternoon. But unless I'm missing something, the only other thing that we've got teed up to address this morning is the objections. Okay. Give me 1 second.
Oh, hello, Monica. What's happening?
Okay. All right. I got an email this morning from Juror Services. Juror number 551. I don't recall from what panel. No, I'm sorry. Juror number 471, panel 3, seat 48. Tested positive for COVID, and Jury Services has instructed him not to return. Juror number 551.
What was the first one?
Sure. Juror number 471, panel 3, that would have been yesterday morning, seat 48. Advised Jury Services this morning that he was not feeling well. After leaving the courthouse, he tested positive for COVID. I have instructed Jury Services to excuse him because we don't need that floating around. The other juror, 551, I don't have any other information as to what panel or seat. She took a COVID test and was negative. She is planning on reporting today. So due to the shrinking from 54 to 53, jury selection will take place here in 12 Alpha this afternoon as opposed to the 23rd floor. The deputies have already brought in additional chairs so that we can fit 53 people in here. That's the only other housekeeping matters that I have to address. So are there any housekeeping matters to address from the state before we address the objections issues?
Is it wise to not utilize that expanded space when two of these panels, or at least one of these panels, has already been exposed to COVID up in the 23rd floor? Would it not be wise to use the bigger space in 23 since one of our panels has already potentially been exposed to COVID, as opposed to packing everybody in like sardines?
Response.
I don't know the layout of 23, so
Can you all approach this for a second?
That's kind of hard for the judge to rule against, isn't it? You know, would it not be wise to have the proceedings in a bigger courtroom so we're not packed in like sardines because one of the jurors may have already been exposed to COVID? Judge just turns around and says, "No, we're doing it here. Okay, wear a mask, pussy." You know, you'll catch something much worse from chicken cacciatore than COVID, believe me. You know, Hep C. Who knows where that guy's been? Yeah, right writing. You know what? I'm just going to leave your message up here for a while, and if we book them, they will come. Maybe someone will listen and head over to buymeacoffee.com and support the channel. Look at the way she does this. She's, you know, she thinks she has really good, like, courtroom manner. Like she's acting proper, well raised. I'm so organized. I excel at everything. Look, I'm shuffling these papers. Man, she's never gonna lose that that chin skin, is she? That chin skin is there to stay. Let's see that again, but zoomed in on the chin skin. Oh God. Oh no. That's tequila that's done that. Hey, Colleen, who are you talking about? Me? I was thinking about getting a fat cigar, actually. Yeah. I'm quitting smoking cigarettes. I'm going on to cigars now. Yeah. And then pipes and then chewing tobacco. And then I'm on to the nicotine gum. Oh, it's vodka that does that, is it? Tequila keeps people thin, I think. Yeah, I'll do it tomorrow, Colleen. I'll get the biggest cigar I can find. That'll be fun. It'll probably last me the whole show. Okay, we got. Oh, there's a bit more Kranich here.
I read you what was provided to me. Okay. Court's going to be in a 15-minute recess. Thank you.
Okay, skipping forward. Got to get through this today. We're already a day behind here, folks.
You ready? We're back on the record. 2020 CF 2603, State of Florida versus Sarah Boone. State.
Dave Kester on behalf of the state. William J. for the state.
Defense. Ms. Boone is still seated at counsel's table wearing the same gray suit and white
Smokers Sheds. Wasn't that a fun time?
blouse from this morning. Can y'all approach?
Oh, there she is. Bitch face, bitch face. Gosh, she's just got such an attitude, that woman, hasn't she? I don't find it appealing at all. She can have the nicest hair in the world. Just cheer the fuck up, will you? Well, even in that split second of a blurred camera pan, we just catch this attitude from Detective Chelsea. Glaring at someone. God, smile for fuck's sake. You know, if the wind changes, your face will stay like that. Maybe that's what happened to her. At least Sarah can smile. You know what I mean? As repulsive as she is. She loves sorting out those papers, doesn't she? Looking busy, keeping busy. Will they have another break?
All right, we're back on the record, 2020 CF 2603, State of Florida versus Sarah Boone. State, you can get appearances.
William J. for the state.
Defense. All right, thank you. Ms. Boone is still seated at counsel's table with the same clothing from this morning. All right, I've been
Hey, thanks so much for the sticker, Laura. Much appreciated.
provided by Madam Clerk, defendant's fifth amended reciprocal discovery exhibit list.
Yeah, she had a good birthday, Laura. We got her some fresh tuna. She's used to canned tuna, so that was different. And yeah, she seemed to enjoy it very much.
I haven't had the opportunity to review it yet, but it is in my hands. Let's start with the defendant's objections to state's digital exhibits. I'll turn it over to you, Mr. Owens.
Judge, and I did want to say that the notice of provision of defendant's fifth amended exhibit list was e-filed on October 3rd. The fifth list was emailed to the state on October 3rd.
Correct. But the same problem I have is it's just the notice of provision. I don't know what any of the substance was. All right, you may proceed, sir.
Judge, I'm going to handle this.
Okay, go ahead.
Oh, here we go. He's about to announce this week's menu. We've got a what other barbecue favorites are there? Oh man, I've gone blank. What do they have? Turkey legs. It's like a chicken leg, but 5 times the size.
And Judge, this was a little bit of a new procedure because what I did was
Yeah, true that, Neverly. I think we're going to need the initially allotted 3 weeks, right? Just because of this guy.
review the images and these, as in the motion, we object to all the cell phone photo evidence. The state intends to introduce a trial as to, I'm not going to know until I hear evidence or see when they're trying to introduce it, if it's relevant or not at that time. Something might make something relevant at a certain time, or it might not make it relevant. So there, and also as to just the foundational stuff, because the images, as I've seen it, I don't have dates. So I don't know when it was taken in relation to the February 23rd, 2020 date, which is the date of the offense. And so I'm at a loss for that.
That's a nice observation, Nola. Sarah is a faux intellectual, just like Ezra. Yeah, I think Ezra dressed it up even more, huh? I mean, she really kind of works to represent as an intellectual. Sarah Boone just thinks people assume that about her for some reason unbeknown to me.
So I don't know if it's 2 years before, does that make it relevant? If it's 3 years before, I don't know. So that's going to be, if the foundation is laid, that's my problem with these photograph exhibits, is I don't know until I hear who's trying to put it in, how's it identified, and if the proper foundation is made to make it relevant. Okay.
Response?
Is this going to be considered a separate hearing for
Mr. J's getting ready, isn't he? How much stuff is he bringing to the podium now?
the record? So should this be D or should it be A?
Everything was, when I called what was being heard today, it was all in the same hearing. So I believe it should be pre-marked as D.
Victoria Girl, we've decided that they found this other attorney at the bus station, slapped a suit on him and told him that they can do it, that he can pull it off. He doesn't need training. They gave him $20 and a bus ticket home and just pulled him in off the street.
What I'm having Madam Clerk mark as D for identification for purposes of this hearing is what has been provided to the defense as the very narrowed down portion of the phone extraction carve out. What it has is what, and we were even so specific that we labeled one part of the PDF case in chief pages, of which there are 59. We labeled rebuttal pages, of which there are 108. Attachments that go to the case in chief timeline. Count up as 80 photographs and videos. Attachments and rebuttal. Count up as 147 photographs and videos. There is metadata that comes with all those files. So there is a date stamp and time stamp on each of those files. For instance, 12/25/2019, 1:10 p.m. Another one might be 10/26/2019, 6:06 p.m. They all have file names. Providing context would be the PDF outlook or PDF outline of the phone extraction, of which the state will now move into evidence so that the court consider this as states 4 for the purposes of these hearings.
Any objection to what was pre-marked as D? All right, that will received without objection as states 4.
So just to give the court an example.
It's got a little dull in this motion hearing, hasn't it? I'm waiting for the bit where Mr. Owens comes up and asks for the 5 peppermints and 2 packs of chips. What are we thinking? Cool Ranch Doritos? I see in Sarah, in my mind, is a big Cool Ranch Doritos kind of girl with what flavor Pop Tarts are we betting? Strawberry Sensation, I'm thinking. Yeah, good point, Neverly. I don't know about 5 times the speed, but at least 1.25.
On page 49 of 59 of the PDF labeled case in chief, entry 31107 in this PDF from the phone extraction is labeled videos, 2/23/2020, 11:12 p.m. 45
Yeah, I believe it's opening statements tomorrow, riding shotgun in the AM. I don't have that confirmed, but I have heard that from another source.
5 seconds, UTC -5, which means corrected to Eastern Standard Time for that time of year. And it's image_1062.mo.
Hey, thanks so much for the coffees, Laura Lee. Much appreciated. Is that the same Laura that's on the channel? On the chat, live chat?
V. So that sort of information is going to be there for the majority of these files. The ones that end up getting recovered from unallocated deleted space are sometimes not going to be there. But there will be contextual clues as to their relevance. The court will be able to see that. So for instance, that image is the 2-minute infamous video of Mr. Torres being in the suitcase that started at 11:12 p.m., 45 seconds on February 23rd. So there is context that can be used both on the metadata that's in the file when you list these files by details instead of by icon, and then within the timeline. And what we have carved out is the case in chief timeline has a conversation that begins on Christmas of 2019, and it starts with Mo, presumably the decedent's brother, having a conversation with Sarah Boone, the owner of the phone, and it culminates in hide and seek, I shall. That's the context of that conversation on December 25th. Then it goes down to conversation that's going on January 12th into the 13th of January of 2020, culminates in a text from the owner of the phone saying, "And bless you and all of you too, I'll get capitals rid of him." So that's the context of those portions of our case in chief PDF. And then there's just the timeline that starts with February 23rd, 2020 at 8:35 in the morning and goes through the entire day to give context of what is going on with her on the phone. Is she using it? When is she presumably awake? That's the context of that file. The rebuttal file, which is, again, 108 pages, it starts, and it basically involves with conversations with or about the decedent, conversations with his family, which I anticipate the defendant is going to testify she was terrified of, and there were problems with all the time. It's going to give some context to those things. It mentions when they became a relationship on Facebook of March 8th of 2018 to give context as to when perhaps this relationship started or not. And then there's a timeline that starts from May 21st, 2019, that is filled with conversations about and with the decedent. At that point in time, he had his own phone, and then at some point he doesn't. And the discussions and the arguments between him and the family with the defendant. And then the images that are associated in the folders, case in chief and rebuttal, are the ones that are associated in these timeframes. I have cleared out the vast majority of them. The vast majority of them were just icons and things that belong to games and nonsense. I cleared out all the photographs of Mr. and Mrs. Boone's child, any of the child's friends. There was no need for any of the pictures of the children. It's mostly photographs of the decedent and the defendant, but there's also just pictures of art and them going out because it gives context. You know, if she's in the middle of an argument, for instance, with the family, you know, one might expect there to be pictures of injuries. Instead, there's pictures of art. So we did our best to select which photographs and videos were pertinent within these timeframes. We did our best.
I think the pictures of art are pertinent and should be shown at trial. You know, I want to see what their art was like.
To narrow it down to what timeframes we set, we believe will give a good rebuttal picture after she testifies about his family and her relationship with him. So that's where we're at. So as far as like the relevancy, the general relevancy objection that was made, there was no specificity as to what particular entries in the PDFs are objectionable for any particular reason. We believe that everything is relevant. Again, we are submitting it for the court's review. I know that we're on the third day of jury selection, which will apparently resume in 81 minutes. If there's an authenticity issue, because one of their objections was relevancy, foundation, unknown origin date, hearsay, and Crawford issues. I'm submitting for the court, if I can approach the court. Gilbert versus State, 324 Southern 3rd, 598.
Yeah, right, Colleen. We might have discovered a hidden gem, the Pablo Picasso of Winter Park, Florida. You know, hidden under a mound of what was the name of the wine? Wind bridge, whatever. Cheap wine boxes and Pop Tart wrappers have buried a treasured artist in the making.
From the Second District Court of Appeal decided in 2021. Lamb versus State, 246 Southern 3rd.
Yeah, thanks so much for the support, Laura. It means the world on the coffees. Yeah, link in the description, guys. Anyone want to follow Laura's fantastic lead and support the channel with some coffees? That'd be fantastic, guys. Woodbridge, that's it, Albert. Thank you.
400 from the Fourth District Court of Appeal decided in 2018.
Just when a bottle of wine is called Woodbridge, like what is the cheapest shit in England? It's Echo Falls. You know, how is it possible that you can tell a shitty, cheap, non-bottle of wine by these names they give them, like Echo Falls or Woodbridge? You know? It's so funny because they're designed to sound exclusive, but they sound exclusively shit, don't they? Bottle of Woodbridge, bottle of Echo Falls.
Gale, Gayle versus State, 216 Southern 3rd, 656, Fourth District Court of Appeal case as well in 2017. The basis of these three cases are just a very low bar for authenticity. As Professor Earhart from Florida State University would tell us, authenticity is a very low bar for the court. It is.
No, it's funny because in Portugal, you can get a great bottle of wine for €2. It's, you know,
generally considered a matter of weight for the trier of fact. And with this digital evidence, it can be established and authenticated in a variety of ways. What the state expects the evidence is going to be is that the defendant's phone was taken from her home by law enforcement, as we know from the motion to suppress, and it was provided to a digital forensic examiner who was able to use the defendant's passcode to unlock it and perform a digital extraction. So that.
Mary, when people did you get some gift memberships? Because there's usually a notification, like when people make a super sticker, it shows up in the chat. So if you did purchase gift memberships, maybe you didn't click on the final submission button or something. I'm not sure, because people have bought them on here before, and like with the super chat or the super sticker, the box comes up in the chat messages and announces that someone bought gift memberships. So the indications are that it didn't go through if you did buy some. And thank you if you did, but maybe it didn't finalize.
Should clear up most of the authenticity issues as to who the owner of the phone is. The state readily concedes and has provided context by using extra pages of conversations that at some point the decedent no longer had his own phone and was using Miss Boone's phone from time to time. In fact, that is part of her allegations about pornography and contacting other women. But I believe the context of those conversations makes it clear who is using the phone and who is not using the phone.
Hey, thanks, Amanda, for the gifted membership. That's what it looks like, Mary. The announcement pop up in the chat box.
So we believe that there is no foundation issue. We believe, based on the
Nola, there's no way I could ever remember how to spell the word connoisseur. Congratulations.
defense they are raising, that there is relevancy. We have split it up to the case in chief and the rebuttal. We are specifically only entering the two incriminating statements in the context of those incriminating statements about hide and seek.
Oh, California Amy got it. Welcome to the team, California.
And getting rid of him, plus the timeline of the date of the offense. Then the rebuttal, we have carved it out as best we could to present a picture of the conversations and the tone, as much as tone could be inferred from texts, and how.
What is she writing down? What is she writing down in a hurry? She's writing quite a lot of text.
The relationship was with the family and who may or may not have been the psychological aggressor. As far as hearsay and Crawford issues, I am unclear if they are talking about just in general the digital forensic extraction report itself. One of the cases I gave to you makes it clear that machines are not humans. They do not get subjected to Justice Scalia's version of the confrontation clause that he outlined in Crawford versus Washington in 2004. What he also talked about, though, and what has had some discussion since the Crawford decision was what's hearsay versus testimonial hearsay. Obviously, there's no testimonial hearsay in these phone extractions. There's no implication that any of these statements made by any of the participants in the text conversations were doing so with an eye towards litigation or prosecution. So it's the state's position, number one, that the extraction itself and all the data that is coming from it is not hearsay and is not testimonial hearsay, much less. And the conversations that are going on with the other people.
What are you knitting, Amanda? I mean, the obvious choice would be a scarf, but I suppose it could be gloves. Would be impressive. Can you do gloves?
The statements that other people are making back to the defendant in the carve-out that we've provided aren't being offered for the truth of the matter asserted. There is no hearsay issue. It is to provide.
Everyone does scarves, don't they? I want to see something complicated. How about a pair of dungarees made of cashmere wool? That'd be comfortable.
Provide the context of things that the defendant is saying. I'm going to go bond Jorge out. I'm going to go to the public defender's office and get this taken care of. Or screaming at his family, so on and so forth. Demanding immediate responses when somebody's cutting hair and keeps on telling her repeatedly, I can't respond to you. I'm working. So those sorts of things, it's the state's position, aren't being offered for the truth of the matter asserted. As far as the unknown origin date, I think it's pretty clear from the PDF timeline that there is a date and timestamp to every single.
Good to know, Amanda. You know, winter is coming. Is it one color, two-tone, multicolor? What have we got going on? How creative are you with the needles?
Entry from this phone extraction, and that corroborates with the images. Most of the images, some were from unallocated space, but it corroborates the metadata for these images. So we're asking for that.
So she's mirroring the attorney's body language now. Look.
But it corroborates.
Ah, yes. Every attorney puts their chin on their fingers. And if you're Dan Rashbaum, you put your fingers on your upper lip and smell your fingering fingers, index and middle. I mean, what is that about? How is that your thing? How are you known for smelling your fingers that look like they've just been somewhere? You know,
the metadata for these images. So we're asking for that their motion or their objection to be denied preliminarily. Obviously, we have to lay the predicate properly at trial, but now the court has a copy, and hopefully we can get advice from the court if the court is believing that there are sustainable objections before we swear in the jury, so that the state can pull any photographs or videos, or we can have at least a discussion about those specifics. And then after discussing those specifics.
Nola, I believe that positive toggles are usually to the right, but it should like turn blue maybe or something, like the color should indicate that it's turned on. But I think it's usually to the right hand side is when a toggle is a yes toggle, and to the left when it's a no toggle. I think, but I'm not sure, and I can't check, unfortunately. But if anyone else knows, confirm with Nola.
The state can pull those out before burning a DVD to provide the the jury. We also have the ability to black out entries in the PDFs. Again, no specific objections were made, so it would be our position that they're waived. There was a generalized objection, but so that we're not doing this when the jury is out. Trial is busy enough, trial is tedious enough to not be conducting discovery and doing redactions during the nights and mornings of trial.
Thank you. Response.
Oh, here we go. Here we go.
Judge, I think this procedure calls for a lot of speculation as to the defense part, as to what these photos, examples of the photographs, what's the use of this photograph? There's a piece of art on the wall. I don't know how that's relevant to the case. So without knowing how it's relevant and what their theory is of it being relevant, I have to form the objection. I don't think this is relevant.
What's your response to the lack of specificity? That these are just boilerplate objections?
Hey, Albert, what's dungarees got to do with someone's age? Dungarees are a fantastic invention, and they should be worn by everybody all the time.
To all photographs, all video.
Yes, well, they're not to all photographs and all videos. There are things that we list.
It is an objection to all cell phone photo evidence the state intends to introduce. It is objections to all cell phone video evidence the state intends to introduce.
Because at this point in time, Judge, I can't tell you what the independent objection would be. I don't know how it fits into their theory of the case. That's calls for me to speculate how it fits into their theory of the case.
Man, isn't this painful? The judge is just like, what the fuck? Why are we having this meeting? You don't know anything. You can't give us an overt act. And now you've told us that you object to every piece of video evidence and photographic evidence, but you don't know why. It's crazy. I've never seen anything quite like this.
How can I do that? If they show you a picture, like a picture of artwork, all right, I don't know how that's relevant to this case, or a conversation that takes place between two other people. At the time, I don't know how it's relevant to the case. So what am I supposed to say? No objection to it? And then am I later barred from objecting to it when I don't think it fits, so they hadn't laid the foundation to get it in? It's putting the cart before the horse.
That pertains to the rebuttal evidence. What about the evidence that was outlined that the state intends on using in its case in chief?
That's it, Judge. How do I know they are going to be able to lay the proper foundation for that evidence? How do I know? That's the thing well, I think the procedure goes like this. Yeah, I could be wrong, but I don't think so. The procedure goes like this. The state has a piece of evidence. They have that evidence identified to someone. All right? They get it marked as an exhibit. Okay, at a certain point in time, the state asks if we'd like to introduce exhibit number 1 into evidence. Defense, either objection or no objection at that time. I've heard the witness who've identified it. I know what it is that time, and I have some relationship to it at that time to make the proper objection. Just getting a picture now, and I'm supposed to say no objection. I don't know what they're using it for. Guess what, Judge? The videos of the suitcase, we didn't object to those. Do you know why? It was clear. I know when it was, and I know the purpose of using it. But when you have animate objects on the wall or pictures of individuals, and in this case,
But what I'm reading, it sounds like you're objecting to those. All cell phone video evidence that the state intends to introduce.
correct.
Sounds like it covers the suitcase video to me. All
No, it
means
doesn't.
all.
The suitcase video is listed in the things that we don't object to.
I don't know that. I have image _ 0954. I don't know what that is. Image _ 0980. I don't know what that is.
Okay.
I'm just looking at the words on the paper.
How does it need to be done, Judge?
Well,
Tell us what it is. How does it need to be done, Judge? We put image _ 612. We put image _ 5816. How does it need to be done, Judge? Isn't that telling you what it is that we object to? And also included in that image, if you open it, is the overt act. Man, I don't understand how, in what is presumed to be the most advanced collective system of justice in the world, and this is still allowed to pass? This is acceptable? It's unbelievable to me. I don't get it. I don't. I think they just want to get through this one way or the other, right? It can't be delayed or postponed or anything. I mean, is she going for ineffective assistance of counsel for an appeal? Because I think she'd get it with this guy.
What the state is asking for is a preliminary ruling on these objections.
How do you have a preliminary ruling on an objection when the foundation or anything has not been laid in court for evidence being omitted?
State conceded they need to lay the appropriate foundation.
Well,
It's part of their argument.
okay.
So I'm not going to address foundation. If they're able to establish it is what it purports to be under the case law, under 90.901 and everything else, I mean, he's right. It's a low bar for what admissibility is.
And I have no problem with that.
Okay.
I have no problem with that part, Judge. The thing that I'm saying is, I want to make sure, because I didn't object to something on here, it waives my right to object to it later.
Okay.
That's what this sounds like to me. It sounds like this is a situation, well, Mr. Henderson, you didn't object to this on the state's list of exhibits. You did not object to it. You can't object to it now. I don't think that's fundamentally correct. So I don't know what part I'm missing.
Anything else, sir?
Well, yes, Judge, I would like, because I know it's a different jurisdiction. People do things differently, okay? 30 years, I've never had to do this in a criminal case, okay?
Part of the reason the court issued the order back in August is at that point in time, Ms. Boone was representing herself pro se. And we need to establish deadlines to prevent any ambush or last minute issues. Then you all parachuted in on August the 30th.
Yes.
There was no order. There was no request to vacate any of those deadlines. So those deadlines were still in full force and effect.
Yes, sir.
But the reason behind that was because Ms. Boone at that time was representing herself pro se. And to avoid issues at trial, the court had set a schedule for when certain objections needed to be provided. And I understand your position. I don't want to be in a position where I'm deemed to have waived anything. I get it. But the state's proffer seems to have established some level of relevancy for these things. And as we well know, the bar for relevancy is very, very low. As to foundation, I agree with you. And the state concedes that point. They need to establish the appropriate foundation. And if they're able to do that, I'm not foreclosing you for making objections. But as of this point in time, your objections are preserved for the purposes of trial. You can raise them, certainly. But at this point in time, based on the state's proffer of what they intend to use and why they intend to use it, I'm going to find that it's relevant and not repetitive.
Judge, at this point in time, as a pretrial ruling that doesn't waive my right to object to something as they're trying to admit it based on relevancy, foundation, or any of those things.
Yeah, I think it was a Victoria girl. I think it was a correspondence course from the University of Aruba. You know, that's where he did his law training.
Then I don't have a problem with that. What my concern was, the way this looked like to me, if I didn't make an objection to it at this time for this, I am waiving it at trial.
I understand. Any clarifications or questions with regard to the court's ruling?
We're just, I believe we're trying to treat this like a video interview redaction issue. Like, it takes time to go back and pull out pictures and pull out videos or black out lines or remove pages. That's all we're trying to do, is do that today. I don't know what the defense expects to be different at trial what more information they're going to learn from the digital evidence. I mean, the foundation for this evidence is going to be the law enforcement officer that took the phone that is pictured in the CSI photos out of Miss Boone's apartment. It's right on the nightstand next to the suitcase. And then that person's going to have to testify, well, I gave it to Junella Wadden. And then Junella Wadden is going to come in and bring the phone with her and say, this is the phone that I plugged into my Metrix Cellbrite software or whatever she used on that particular day. And this is how Cellbrite works. This is my educational background, blah, 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 with this software. And I pulled this extraction out.
Did he just say blah blah blah? This is my education background, blah 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 blah. Is that professional?
Mr. J. And this is how Cellbrite works. This is my educational background, blah, 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 with this software. And I pulled this extraction out. Mr. J sent me this carve out of this extraction before trial. In fact, she picked it up yesterday.
You know, he's actually semi-quoting the expert witness that's going to come in and testify. How is that person supposed to feel when they see him say that? She's going to come in, she's going to say, this is the Cellbrite software. She's going to say, this is my education background, blah, 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 blah. That's rude. It's rude.
Yesterday. And I believe, you know, I'm going to testify that this is part of the larger carve out. This is from her.
Man, doesn't Mr. Chicken Cacciatore look like he has a terrible home life? Like his wife just berates him all day long, you know, calls him a loser, beats him round the side of the head with a frozen loaf of bread. You know, he's one of these guys that stays late at the office even when there's nothing to do. You know, he's just like a broken man, a shell of his former self. You know, he should do something to help his self-esteem. You know, he should join a sports club, or maybe take a creative college course, you know, on the pottery wheel. Maybe the pottery wheel would be good for him. It's a very meditative thing, you know. It gets you in tune with the clay, and you know, you get a sense of achievement when you pull your pot out of the kiln. And you know, but knowing him and his home life, he'd probably take it home to his wife and she'd bust that around the side of his head, calling him a fucking loser. You know, a sad man, a broken man.
Her phone. That's going to be the foundation. The rest of these things are things that we should be able to have an intelligent discussion about today with specificity about this line of text isn't okay. This particular photograph's not okay for this reason. That's what we were hoping.
Okay. Have you reviewed what it is?
I'm not sure that Mr. J has a wife, if you get my meaning. Like, he's a little bit camp, isn't he? Like, good fashion sense, loves the opera.
Specificity about this line of text isn't okay. This particular photograph's not okay for this reason. That's what we were hoping.
Okay. Have you reviewed what it is that the state intends on eliciting in this exhibit?
Yes, Judge, this is the things that I reviewed. I sit down.
Yeah, Charlie Adelson will be getting a retrial. I started off the video with my brief thoughts around that subject. Pretty amazing, huh? I mean, talk about shit coming undone. You know, what are the Markells supposed to think of that? Jack Campbell, you've got no business sitting in that fucking office. I don't care. The fact that you're elected to run it means that the electorate don't know what the fuck they're talking about. You are clearly incompetent. I know nothing about what you do, virtually nothing. about what your position means to that office. I follow a lot of trials, but my focus is usually on the trial attorneys. As far as what his actual role is, I'm not that sure, but I know how to spot a fucking person who's shit at their job, a person who can't justify their actions and non-actions, and that is you, Jack Campbell. So do yourself a favor and the people of Leon County a favor and fuck off out of that office. Please. Anyway.
Last night and went through every one of them preparing for this hearing. What we did not, or what we failed to do because of the time restraint for the ones that we didn't list the number and I didn't give detail as to like IMG 0954, what it represents. My concern is this, because I don't have a problem with this or with the state's evidence at this time, as long as it's not a bar that when we come into court and I feel something is not relevant at that time, or they go to admit it and I say objection relevancy or objection foundation, then I'm not barred at that time. I don't know any rule that would bar me at that time.
Okay. I'm going to overrule your objections for the reasons that I previously identified. You can raise your objections at trial if you deem necessary, but based on the state's proffer, I'm going to find that the different categories of documents that he's identified as reflected in Exhibit 4 are relevant. They are not repetitive. They are not cumulative. And so long as they can establish the appropriate foundation and based on counsel's proffer, seems like they might be able to do so. Any questions, sir?
Now, I just want to add something for the record.
Yes, sir.
The state during its proffer said there were no photos of the child. That's not correct. There are photos of the child.
That are being sought into evidence?
Yes, Your Honor.
State? Response, if any?
Look Oh, chicken, what are you doing? Someone give him a hug. Tell him he's doing a good job. For fuck's sake. You don't put your hand on your face like that unless you hate your life. Okay? Get a divorce, man. Tell her who's boss. Walk back into that front door and just lay down the law. You can do it, chicken. Come on, chicken. Stand up, be a man. You know? What's happened to this guy in his life? He's the sort of guy that would attach a hose pipe to his exhaust and run it into his car window and just sit in there and cry himself to sleep. A long, long sleep.
I don't believe so in either of the folders. I don't have any independent recollection if I tied it up more than when I gave them what I believe the exhibit to be a week or two ago, but I don't see any.
I think Sarah's co-counsel was just confusing 5'2", 103-pound George for the 9-year-old son of Sarah and Brian. There are pictures of the child in the evidence. That's the decedent. He's 42 years old. He's just little. Hey, Laura says that Charlie will take a deal. I'm not sure he'll be offered a deal, you know. And even if he could give solid, no-nonsense testimony against Wendy, I don't see him getting a deal that's going to do much for him, like 40 years, 30 years, maybe 30 years he could get. So he'd be 77 when he was released. I mean, big deal. You know, he's not gonna get any kind of deal that would see him walk out of jail. That's just not gonna happen. Isom car guy, Evan. I love Isom and his cars. It was so great when he was interviewing who was it? That redhead, you know? I forget her name. I think it was Elizabeth. It was something German. Schmidt. Was it Elizabeth? It was definitely Schmidt. I remember her spelling it out. But she's like, they used to live up on somewhere in Tallahassee. I forget the place. Tell me their car. What kind of car do they drive? He always asks it in the same frame wording of the question as well. He doesn't change it up and say, and what kind of vehicle do they have? It's always, what kind of car do they drive? Yeah, Sarah's putting the finishing touches on her giraffe picture.
Okay, I see two images. I couldn't recognize it as reflection of children in I don't know if it's a snow globe in an aquarium or whatnot, but I have no objection.
Well, Riding Shotgun says that hell no, Jack Campbell's off the ballot for 2024 because no one is opposing him. Well, then it's the fucking whatever panel of higher ups need to take a look at it. If no one's opposing to him, why? They'd fucking walk all over him. You know, it's a cushy job. I mean, he must be earning bank, right? Someone needs to oppose him. I'm gonna do it. You know, I could handle his job better than him online from Portugal. Just as soon as I find out what it is he actually does, apart from drop every ball there is, you know. Someone needs to step in, whatever chain of command or whatever is involved. The people above him need to take note and do something about it, because this is what is the biggest case in Tallahassee history. I mean, how could you fuck it up this bad? How is that even possible? The only saving grace that he could do right now is go and arrest Wendy, bring her back to Leon, go and arrest Harvey, bring him back to Leon, make them all sit in jail, put the boys back in Toronto with the Markells. That would be something. That would be a move that would satisfy some state of affairs for a while their office sorts their shit out, you know? But is he going to do that? No. Do I have any faith he's going to do that? No. Why? Because he doesn't do anything that's good.
To removing those two. I just didn't recognize it as children. I recognize it as a crab.
I haven't seen the picture, so I'm at a loss.
A crab? What is going on? We had a dog drinking Woodbridge Chardonnay and doing arts and crafts. Now he's talking about that's not a child, it's a crab. You see, that's what I mean about these cases. You just never hear sentences like that anywhere else. Let's hear it again.
Globe and an aquarium. Okay, I see two images. I couldn't recognize it as reflection of children in I don't know if it's a snow globe and an aquarium or whatnot, but I have no objection to removing those two. I just didn't recognize it as children. I recognize it as a crab.
I didn't recognize it as children. I recognized it as a crab. I'm surprised that the defense attorney didn't stand up and say, yes, a crab, a child crab, a very, very young crab, you know, with little baby claws.
I haven't seen the picture, so I'm at a loss.
I'm at a loss. The judge is at a loss over the child crab with baby claws. You know, what is going on?
Well,
I'm sorry, Judge.
Extraordinary file name, but I'm going to remove those two exhibits that they're
I'll
talking.
take care of that issue for you, sir.
That takes care of that issue, Judge.
Okay.
But the point that I'm trying to make with that and why I raised it is that there are going to be certain things that I'm not going to know, and to what is the purpose of it as far as how is it relevant now? They can make a proffer. I understand they can make a proffer, but their proffer isn't evidence. Once it goes up, the witnesses and all, and the court has told me that I don't waive my objection, so I understand the court's ruling.
Okay. All right. Thank you very much.
Yes.
Anything else with regard to the defendant's objections to state's digital exhibits, Mr. Henderson?
No, Your Honor.
Okay. Moving now to the defendant's fifth amended reciprocal discovery exhibit list in the state.
Hey, I don't know why you're saying 25 years for Wendy, Laura. I mean, that's not enough. That's nowhere near enough. You know, I like that you've put the gorilla down here. That's the ultimate justice for Wendy Adelson. Being stripped naked, covered in peanut butter, and thrown into the gorilla enclosure on Zazu the Silverback's birthday. That's real justice for Wendy.
State's objections to same. There are some for which the state has no objections. Those need not be addressed. It will just be dealing with the objections outlined. It is not lost on the court that it is 12:30. We do have a jury coming in an hour. My court staff does need a lunch break. So how do you want to proceed, Mr. J?
I just want a ruling before we swear in the petite panel.
Okay. Do you have any concerns with proceeding with jury selection this afternoon and the final portion of the court's inquiry as addressed yesterday and turning it over to you without having a ruling on these? And we could address these objections tomorrow morning before we bring in the balance of our panel? All right, is that acceptable to the defense? Okay, all right, so then here's what we're going to do. We're going to be in recess till 1:30. We will report to the 23rd floor. I've already advised jury services and court admin that a room is available for us. We will continue jury selection at that time. I will keep you apprised of whether or not we can continue jury selection in 23 tomorrow. As soon as I have that information, I or my judicial assistant will pass it along to you. Assuming we're in 23, we will advise the jurors when they need to return, and we can address all these objections tomorrow. And we'll address those objections either in 23 or in 12 alpha. Anything further from the state?
No, Your Honor.
Anything further from the defense? Okay, we will see you all at 1:30 and 23. Thank you.
Okay, so we didn't get the thing about the snacks for Sarah, but luckily enough, I have a link. I thought it was in this video, but here we go. Or is it this one? Ugh.
Judge, my client tells me that they wake her up at 2:30 in the morning, and then she's kept in a holding cell until she's brought to court here at 6:30 in the morning. And then, of course, she's brought up around 9. And then she'll leave today about 5:30 or 6 and be in 2 different holding cells. She'll finally get to her dorm about 9 or 9:30. They stopped allowing showers after 9 p.m. She got there after that time, but they allowed her to shower since she hadn't had one. She's asking that, they get commissary there at the jail. She's asking that the officer that escorts her be allowed to bring her commissary. She's asking for 2 juice packs, 5 peppermints, 2 bags of chips, a bag of candy, and a bag of either cookies or a Pop Tart. To allow.
So that was 2 juice packs, 2 bags of chips, Cool Ranch Doritos, I'm betting, 5 peppermints. What else was it? A bag of candy and either cookies or a Pop Tart. I mean, what the hell? If I were a defendant in a trial, I would be too embarrassed to have someone read out that request on my behalf. Talk about fucking juvenile. And what is the thing about 5 peppermints? Why does it need to be 5? Why not just a packet of mints? How many mints are in a tube? Probably about 20? What a weird request.
Allow her through the day. I think they serve them a peanut butter and jelly sandwich down.
Peanut butter jelly sandwich is good enough. You should be happy with that.
In the basement lunch, but she's not diagnosed with any kind of blood sugar, but she says she gets like today, she's feeling tired and lethargic. And so she feels like those items during a break that she could have something like that to keep her energy level. I'm asking for the court's permission that she be allowed to do that.
State, any response?
not the state attorney's office and any of the parties involved.
Okay.
Yeah, the state's attorney, like we don't have a response. We don't give a fuck about that. She can have 50 Pop Tarts. You know, we're putting her away for life.
I will speak to the captain at the jail if I can get a hold of her before 5 o'clock tonight and see what, if anything, we can do. I can't make any promises. My understanding from the deputies is that there are 2 bagged meals which are given, which include cookies as well, that are provided for Ms. Boone. And that's for all inmates that are stored downstairs during trials. So I'll inquire of the jail staff if I can get a hold of them this evening, and hopefully have an answer, if any, tomorrow. All right. Anything else?
Okay, guys. Well, as far as I am aware, trial starts tomorrow morning. So we'll do our best to be covering that live as it happens. I guess it's going to start at 9, but I'll check that in the morning and see where we are. Looking forward to opening statements, though. And it sounds like we're going to have quite a bit of evidence come in. Photos. We've got photos of a child crab in a snow globe. Okay. We've got a photo of a dog drinking Woodbridge Chardonnay, doing arts and crafts and listening to music. Okay. I mean, we've got the defense duo from, I mean, it's like a joke shop. It's like the defense team that you get out of a Christmas cracker, you know, like a really shitty prize that's a joke. And the only thing good about it is the paper hat. And you don't even get a paper hat here. It's just a shitty defense team. I mean, we've got Chicken Cacciatore, who basically looks like he's going to go home and sit in the bathtub and slit his own wrists. I mean, God bless him. And I hope if he needs support and help, he's brave enough to pick up the phone and call it, you know. Maybe we should reach out to him and just send him some pamphlets, you know, some hotlines, you know. He probably just needs someone to talk to. And he's not going to get it at home. His wife just, you know, is probably physically abusive. I swear he stays in the office late at night, even when there's nothing to do, and just sits there alone. You know, it's very sad. You know, we'll try and find out who his rehab probation officer is or whatever, and let him know that it seems like he might be close to another episode. God bless him. And meanwhile, Sarah wants a Pop-Tart. I mean, what the fuck? Unbelievable. It's been denied, by the way. I know that much. Lee, how are you doing? You're always so late, Lee, but it's always good to see you. What does Lee say? Lee says, I can't wait for sentencing day. I hope this judge gives her the talking to that she so badly needs before he tells her life in prison. Yeah, he might do. I love that part of trials when that's when you really find out who a judge is, when it comes to their sentencing statement, right? We see, I mean, Judge Everett was pretty just handed it out, didn't really make a big speech to Charlie Adelson, very keeping it on the business level. But then you've got other cases like what's his name? That the black judge out of South Carolina. What's his name? He did a really good one in the Nathaniel Rowlands case. Anyway, that's for another day. Oh. Okay, it is 4:17 a.m. and we're going to close it down for tonight, guys. Many thanks to all the people joining the chat. Oh, Mary, thanks for the coffee. We just seen that come in. Yeah, you can support the channel all day long, guys. There's a link in the description to buymeacoffee.com. It's all very much appreciated. And yeah, thanks for the likes, thanks for the comments, and thanks for just being here and being yourselves. And we'll see you tomorrow with Sarah Boone opening statements. Very nice. Judge Newman, yeah, that's it. Riding shotgun. Also did the Murdoch case that I haven't watched. Yeah. Great comments tonight, Colleen and Nola and everybody. Okay, guys, catch you later. True Crime Metrix out.